For motion supplementary item 18.
Yeah, please, Your Lordship.
Yes.
Lordship, here the matter pertains to rejection of tender during the technical bid evaluation. Here, the District Commissioner of Biswanath District, that is the respondent number 3, issued an NIT dated 2706 inviting tender selection and appointment of handling and transport contractor for transportation of food grains
Why was the tender rejected?
rejected.
Reason?
It was due to a clerical mistake, Lordship. One condition of the NIT was that the participants had to upload a solvency certificate.
Huh?
A solvency certificate issued from the bank's end, stating that the turnovers will not be less than rupees 3
What?
crore.
Yeah.
That is the condition. Part is at page 26 of Annexure C, the relevant portion. Page number 26, Your Lordship.
Page?
26 of Annexure C.
Ah.
The bidder shall have to upload the copy of solvency certificate not less than rupees 3 crore received from the bank along with a copy of audited financial statement. Now here, Lordship, the petitioner had already uploaded his solvency certificate, but there was a clerical mistake on the date part. Instead of the day, the intended date was 15/07/2025, but it was typed as 15/07/2024.
Which one?
It is on page number 33, Lordship, Annexure I, your solvency certificate. The top part, the date, 15/07/2024.
So it should have been what date?
The date should have been 15/07/2025 for the current year.
Now, what is the date of should have been?
The date should have been 15/07, but instead of the year 2025, the intended year was 2025, it was typed as 2024. But if your Lordship may peruse the content of the solvency certificate, it clearly indicates that the solvency certificate was indeed issued towards the present NIT.
But this is 2024.
That is what, Lordship.
So they have wrongly given it.
Yes, and the bank has also issued a correction certificate stating the same, that the mistake was done from the bank's end. But the petitioner's tender was rejected due to this very reason.
So is there no scope for seeking clarification?
That's what, Lordship. What we are seeking is that they may take instructions.
These documents was uploaded in the my lord portal, my lord. Therefore, my lord, whether after that these documents, subsequent documents.
One has to also understand.
Yes,
You see, they have mentioned about the tender notice in that document of 27/6/2025. It could not have been 15/7/2024.
yes,
At best, they should have asked for some clarification.
yes, my lord. And they have submitted a representation, my lord. In that view, my lord, they may consider that document, my lord. It's 40, my lord.
Page 14.
And you were rejected when were you informed about this?
Lordship, through the
7/8, nah?
Yes, Lordship. And we have taken action promptly. On 7/8 itself, we have submitted our written representation to respondent 3.
Madam, why have you not made those other two parties, other
Lordship,
three persons as parties?
Lordship, here, the enterprise which has been selected, since the workload is not yet allotted, it's not a necessary party.
Huh?
The enterprise, the tender, where the other party, if your Lordship may peruse.
39?
Yes, MS Vivek Enterprise, even though they have been selected, the workload is not yet allotted to them. Therefore, it is, they are not a necessary party to this petition, Lordship.
Very good. Issue notice returnable on how long?
My lord,
I'll pass a stay order.
7 days, my lord. 7 days.
You can get your instructions, file your affidavit.
Yes, my lord.
Issue notice making it returnable on 27th of August 2025. Mr. M. Sitya accepts notice on behalf of the respondent numbers
All last one.
1, 2, 3, and 4. 1, 2, and 3.
120.
The petitioner hearing, extra copies of the petition be served upon him during the course of the day. The petitioner herein is aggrieved by the rejection of its technical bid by the email dated 7/8/2025. The materials on record show that a notice inviting tender was issued for handling issued by the respondent number
3.
3, my lord.
3 for handling and transportation contract of food grains under NFSA 13. For which year?
Lordship, for 2025. So,
Huh?
Tender
No,
petition
food
date.
grain and of Biswanath district by the notice inviting tender dated 27. What is the date?
Tender publishing date is 30/06/2025.
27/6/2025.
27.
Full stop. Amongst the various terms stipulated in the tender notice, one of such term was that the bidder has to upload the copy of the solvency certificate not less than rupees 3 crores received from the bank along with the copy of the authenticated audit financial statement bracket balance sheet, profit and loss account for the last 3 years, that is 2022-23, 2023-24, and 2024-25. The petitioner, along with various other tender bidders, participated in the said tender process. It is further pertinent to take note of that the petitioner, in terms with clause number 5 of the notice inviting tender dated 27/6/2025, submitted a solvency certificate issued by the branch manager, Nagaon branch of the Indian Bank. The said solvency certificate has been enclosed as Annexure E to the petition. From a perusal of the said solvency certificate, it transpires that the date was put on 15/7/2024. Though it specifically refers to the tender notice in question, that is ECF.136.334/426/7895, dated 27/6/2025. A perusal of the said solvency certificate, therefore, a perusal of the said solvency certificate, and more particularly the date mentioned therein, appears to be therefore incorrect and could not have been issued in the year 2024, as there is a reference to the notice inviting tender dated 27/6/2025. The grievance of the petitioner herein is that the petitioner's technical bid was rejected on the ground that the solvency certificate was dated 15/7/2024. The record further reveals that the petitioner immediately thereupon submitted a representation on 7/8/2025, enclosing therewith another certificate issued by the branch manager, Nagaon branch of the Indian Bank, dated 7/8/2025, wherein the branch manager of the Indian Bank had duly mentioned that there was a mistake committed by the bank in putting the date. The grievance of the petitioner is the respondent authorities have no intention of considering the said representation. And it is under such circumstances the petitioner has approached this court. This court had Mr. M. Setia, appearing on behalf of the respondent numbers 1, 2, and 3, submits that as the contract in question pertains to handling and transportation of food grains under the NFSA 2013, the instant litigation requires to be disposed of at the earliest, and as such, he would file the affidavit on or before the next date. This court, had also heard the learned counsels on the question of interim direction, as to whether any interim directions can be passed in the instant case. First, this court, from the materials on record, it appears, that the dates which have been mentioned in the solvency certificate enclosed as Annexure E to the writ petition as 15/7/2024 appears not to be the correct date, taking into account that in the said solvency certificate there was a reference to the notice inviting tender dated 27/6/2025. It is the opinion of this court that the respondent authorities could have sought for a clarification from the petitioner. It is the prima facie opinion of this court that the respondent authorities could have sought for a clarification from the petitioner as regards the date mentioned in the solvency certificate, in view of the fact that there is a reference to the notice inviting tender dated 27/6/2025. Instead of doing so, the petitioner's technical bid was rejected. This court further, upon perusal of the Annexure E, solvency certificate, wrongly dated as 15/7/2024, finds is of the opinion that is also of the prima facie opinion that the contents of the said document appears to be in consonance to clause 5 of the notice inviting tender. In view of the above, this court therefore is of the opinion that the petitioner has been able to make out a case for passing interim measures. Accordingly, this court further directs the respondent authorities not to not to proceed with the process in respect to the notice inviting tender dated 27/6/2025 till the next date. Full stop. This court further, taking into account the judgment of the Supreme Court in the case of Afcons Limited versus so and so, reported in 2016, 15 SCC so and so, directs the petitioner to, gives a liberty to the petitioner to array the bidders whose names appear at page number 39 of the writ petition. This is a liberty being granted. And if you don't do, then don't tell me.
My lord, if that tender process has already been, my lord, contract has not been already awarded, my lord.
Not to proceed.
If, my lord.
Deeply obliged, Your Worship.
Not to proceed further with the thing.
Item 19,
Page, Your Lordship. Basically, I'm asserting my right regarding extension, my lord. If Your Lordship would kindly come to, my lord, the memorandum of agreement at page 23 is the clause regarding extension, my lord. Initial period, it was 5 years, that is from 1st of July, that is up to 37/23. Second one, unit will be given to the operating agency initially for a period of 5 years, which is automatically extendable for another 5 years on the basis of satisfactory performance as per mutually agreed terms and conditions.
Page 23.
Page 23, my lord.
The unit.
Unit will be given to the operating agency initially for a period of 5 years, which is automatically extendable for another period of 5 years on the basis of satisfactory performance as per mutually agreed terms and conditions. So it is not the case of the other side, my lord, that there was any shortcoming in the performance. So going by the language, my lord, there is a presumption that petitioner expects to get it.
Going by the language, it appears that it should have been automatically done unless they have good reasons.
Of course. Unless they have good reasons, correct. Anyway, all the public interest will always prevail, my lord.
No,
At least my only
the
submission.
good reasons is not satisfactory performance.
Yes.
So if they feel that there was no satisfactory performance, they
Then
may
of
not
course,
extend.
yes. Now, my lord, I have also made some investment, and that's why I'm invoking the doctrine of promissory estoppel also, my lord. In fact, if your lordship should kindly come to the representation, I have spent about another 60 odd lakhs.
Now what has happened? They have issued a tender.
কি দাম কথা বল এক্সপার্ট অর্ডার হয়নি কোন লিখা আছে রেসপন্ডেন্ট কপি দিব লাগে
What one?
My lord, I just want to bring it to your notice, my lord, that the main respondents here are my lord,
রিপ্রেজেন্টেশন
Art Fed, my lord. Art Fed, my lord. 1 and 3, my lord.
Yes, yes.
Impugned order is of by respondent number 3. So, and my lord, they have a standing counsel.
Why,
So
why?
I think copy was not served. His name is not on the call. I am just appearing as a formal party for respondent number 1. That is the thing, my lord.
Standing counsel has not
Yes,
been served.
29.
Art Fed, my lord. I'm just bringing it to your notice, my lord. They have a standing counsel, maybe by
My lord,
error.
we inquired from them. It was told that whenever notice goes from the court, then they will accept it. My lord, if your lordship should kindly come to page 29. Now, my lord, these people are under very wrong conception, my lord. As if, my lord, there is no concept of an ex parte order. There could be an ex parte order also.
And there is,
They're very up and doing, my lord. In every case we find. This is not how the profession will grow. Lordship should kindly come to page 29, my lord.
Now what do you want?
I just wanted to
There's a-
show, my lord, I made investment of 60 lakhs on new machineries and technology. Page 29. when I prayed for renewal, my lord, in terms of the agreement, that this was one of the ground. Two, investment of around 60 lakhs on new machineries and technology. Providing employment to seven.
Standing council?
I can find out, my lord. But usually Artfed gave a council when was I appear with them, my lord.
I'm asking you, are you just saying on a hunch or are you saying on an authority?
No, my lord, they have a separate council, my lord. Artfed, because I never appear for Artfed. Because they are always conflict of interest. Handloom, I am for the department. I am for handloom, my lord. The department, my lord.
I pass an order today on the basis that you say that there is an outfit council, standing council,
My lord.
and if it is wrong,
My lord,
then
my-
you will be,
my lord will give me.
we will
permit-
put you in
permit
the
me-
black book and put it in golden letters, your name. And if not, very good.
My
Take
lord
the
will-
risk.
My lord will permit me 2 minutes time. I will just confirm, my lord, whether, because all the time, my lord, Artfed, there is a council, he comes and appears. So I am not confirmed whether he is standing council, because there are a lot of cases of Artfed, my lord. Non-payment of the salaries and all. So there is a council. So I have to,
My lord, my junior, when they wanted to contact, he said, we will take notice only after court issues notice.
my,
It was Jahid Ali.
Jahid, Mr. Jahid Ali, yes.
He said, my lord, he has got no authority to accept notice directly.
Mr. Jahid Ali.
Now you are, the question is without any reason, they are issuing a notice inviting tender. That is.
Without considering our case for extension.
You have applied for extension?
Yes, yes.
When did your period end?
My original period came to an end on, my lord, 30th of July
5 years would be.
2023.
No, the 5 years would be from
1
30th of
7
June.
30th June, I'm sorry, June
30th of June
Yes.
2023.
3.
Then what happened?
Thereafter, my lord, they initially issued a terminating letter, but thereafter on my prayer, I was allowed to continue.
Without an agreement.
Yes, my lord. Page 29, my lord. This is my application, my lord.
Renewal you have given on 19/7.
7/23.
Then what happened?
Then, my lord, they kept mum for quite some times. Now, my lord, they have come up with this impugn order at page number,
But you have been issued a notice to vacate on
yes,
18/2/2025.
yes.
You have not challenged that.
Then, my lord, we at page 36, we filed the representation.
Then
Then, my lord, they issued the impugn NIT.
Then they issued the NIT.
Yeah.
But if it has not been extended, how is it possible?
So they're accepting the, my lord, rent which I'm paying, 55,000 per month, no? 51,000, no?
Where is it? That
Yes.
they have been issued?
Page number 32, my lord, 31 and 32. Even on 17/5/25, I have paid, my lord, at page 32. Page 32, I paid on 17/5/25. Then, my lord, at page 33, I paid on 7/8/25.
Page?
Page 33.
Page 31, 17/23, after the tax rate of first 5 years. 31. So not because this is based on September.
Page 31, my lord, I paid post the first letter. That is on 11/9/23.
So you are paying as per what, is it monthly payable?
Monthly,
Then why is it 1,63,000?
3 months.
Why?
They accepted, my lord. Actual monthly rent is 51,000, my lord.
That is why I'm asking.
3 months together they have paid.
Yes, yes.
And it's a bank transaction, means they have deposited directly. Man.
Even on 7-8 also they have accepted. ये कौन सा बैंक को जो है? ETL is the right, sir.
But Mr. Chaudhary, you have a
Milord.
problem.
Yes.
You have not challenged 15/2/2023. Page 27.
First one. No, my lord, because they have not given effect to.
No, they have said that we have done.
No, no, my lord.
The concept for lessee, but the
Tenant holding over.
yeah, the other question does not arise. They have it without challenging the termination. How can you challenge the notice inviting tender?
Agreement for termination of my internet.
My lord, my right basically flows from the agreement. My lord. Agreement does not contain any clause regarding termination.
Challenge, therefore, your case has to
Yes,
challenge this.
yes.
Without a challenge to 15/7 and then 18/2, how do you maintain this repetition? Because otherwise, this termination has happened. Now, how can I stop them from going for that?
No, my lord, my humble submission is, if your lordship invokes the doctrine of promissory estoppel, that itself is enough.
Promissory estoppel
No,
does not
technically,
apply.
no,
to contractual
technically,
contracts.
I'm not joining issues on that, my lord. Possibly, this 18-2 I should have put to challenge.
Without this, you 15/7.
Yes,
15/7, you have to challenge. Whether you have received or not, you have how you have paid. These are different aspects of the matter.
we are not disputing about existence of this document. They immediately on 19/7, we filed the representation.
Understood. You
Thereafter-
submitted, but you have submitted. But the question is thereafter.
No, technically lordship is correct, my lord.
You know what? If the termination has already happened, means you have to challenge it. I think you withdraw and
My
file.
lord,
fresh.
what I propose to do, my lord,
Hmm.
I am withdrawing this with liberty to file a fresh petition.
I think better.
Yes, yes.
Hey, Mr. States Council has no rule now. Mr. Ken Chaudhary, the learned senior counsel, assisted by so and so, submits that the petitioner have inadvertently not challenged the communication date 15/7/2023 as well as the communication dated 8/2/2025. While assailing the notice inviting tender dated 29/7/2025. He therefore submitted that the petitioner may be allowed to withdraw the petition and liberty be given to the petitioner to refile by challenging the two documents. Taking into account the above, the petition therefore stands closed on withdrawal. Liberty is given to the petitioner to refile by challenging the termination by the communication dated 15/7/2023 as well as the notice for vacating the premises dated 18/2/2025. If so advised, Mr. Ardoy appears for the respondent.
Raspuno, 1 month.
Deep level.
Wait, please, Your Lordship. It's a challenge to an NIT, my lord. Lordship will have a look at page 192, my lord.
192.
192, my lord.
It can be taken up after some time, my lord. K Google will appear, my lord.
Who?
Mr. K Google.
Let him appear. Come, by the way, I'm a very slow judge. Let me hear what he does.
My lord. Page 192, my lord. It's a, my lord.
Nothing to say, and I can finish it. Yes.
My lord, it's a tender NIT issued by the Inspector General of Prison, my lord, for supply of dietary article under Zone 5 Jail of Assam, my lord. Those items, your lordship will find, my lord, at page 219, my lord.
195.
219, my lord. Page 219.
219.
219. These are the items to be supplied, my lord, in those jails, my lord.
And
Now, my lordship will have a look at page 214, my lord.
yes.
214, my lord. Your lordship will see, my lord, this is an additional terms and condition, my lord. We are agreed by that clause 3, my lord, rate 4, my lord. Lordship had found, my lord, 4, my lord. The tenderer should have to submit their minimum average annual turnover for the last 3 years. The
Huh?
minimum average turnover of the bidder for the last year is,
Which clause?
my lord, clause 3, 4. Sorry, my lord, 4, clause 4.
Ah,
Clause 4, my lord. The tenderer should have to submit the minimum average annual turnover for the last 3 years. The minimum average annual turnover of the bidder for the last 3 years are shown below, 11 crores. My lord, we are agreed by this. Now, if your lordship turns to, my lord, page 201 of the tender, my lord, 201, my lord.
yes.
Below your lordship will see, my lord, 4.1, my lord, evaluation criteria and methodologies, my lord. There, my lordship, below, my lord, 4.1.2, purchase and price preferences. In exercise of the powers conferred in section 11 of the micro, small and medium enterprise development Act, so and so Government of Assam has notified a procurement preference Assam 2015 from time to time in respect of the procurement of goods and service produced and provided by the micro and small enterprise by its department, state public sector undertaking and its aided institution. So the petitioner before your lordship, my lord, their micro,
MSME.
yes, my lord. So
Then
now your lordship will have a look. Yeah.
where is your certificate? Certificate of registration.
Certificate of registration, your lordship will find it page 29, my lord. 29 and
20.
28.
How many petitioners are here?
2, my lord.
Are they forming a cartel?
My lord,
Are they forming a cartel?
are they forming a?
Cartel?
Yes, my lord. Now that policy, my lordship, I have given, my
No,
lord.
I am asking you.
My lord.
Because you see, there are two different petitions.
Yes, my lord.
Who has independent rights?
Yes.
Why are they together? If they are putting for the same tender,
Yes, they are putting for the same tender.
why are they together?
Yes.
The moment you are putting together shows that there is a competition.
Yes, that's true.
Is to be avoided as per the Assam Procurement Act. Are you not going to have a difficulty tomorrow?
That's true.
On this ground, you will be put into trouble. Two
That's-
petitioners joined together. Anyways,
And
we'll
yeah,
do one thing. We'll get this petition withdrawn in respect of one and proceed with the other.
On the, yes, my lord. Then, my lord, petitioner number 2, my lord, I am withdrawing. Anjali Das, my lord.
So you like them.
Yes.
Petition number 2.
Well, as instructed by my friend, my.
Okay, now tell me.
Now, my lord, that policy, my lord, lordship may say that I have just now. That policy, my lord, definition 3, my lord. Definition 3, my lord. A micro enterprise means such enterprise where the investment in plant and machinery or equipment does not exceed 1 crore rupee and turnover does not exceed 5 crore rupees as defined by the Ministry of Micro so and so, my lord.
Yes.
So, my lord, this is the second round of litigation, my lord. Earlier also we approached this court, my lord, but they have withdrawn the, my lord, the NIT, my lord, and issued a fresh NIT, my lord. But same terms and condition, my lord.
Now what do you want?
My lord, I want to participate, my lord.
How?
Because micro enterprise says your turnover should not be more than 5 crores.
But you are going to be, they will be inviting micro,
Micro,
MSME.
MSME.
So if they are inviting on one hand the MSME,
Yes,
then you cannot have 11 crores.
yes, that's the word.
What do you say, Mr. Gogoi?
It says that preference, lordship.
No, no, understood.
Lordship,
So if you are going to give some preference to the MSME,
lordship.
then how will an MSME participate?
Lordship, that,
Because MSCB cannot be, as he says,
that
more than five.
turnover, three years turnover, Lordship, not a single year, Lordship.
Huh?
It's a 3-year turnover, Lordship.
3 years.
3 years turnover, my lord, may kindly peruse page 214.
For the last.
Last 3 years.
As shown.
Average annual, madam. The word is the average annual,
It is average.
average annual.
Yeah, Paris.
For the last means average annual. Every year. So they may have a 33 crore 1 year, may not have 0 in the next 2. Then also they have 11. How do you take care of this?
That
Because
part,
is that part of the same contract?
Yes, madam.
it's a additional terms and condition that,
No, the earlier clause you were showing,
Page, my lord, page 214.
no, the other one, MSB.
MSME, my lord, page 201.
Purchase and in exercise of powers under section 11 of the Iman, the government of Assam has notified procurement preference policy Assam in respect of procurement of goods and services produced and provided by so and so. Mr. Gogoi, we will get your instruction.
Lordship,
I'll issue a short notice.
Lordship.
Get your instructions, but we need to stay this because the last date is when?
16. 16 up to 2 p.m. Saturday.
Let us have it on 20. Can you get it? Your instruction.
Otherwise, Lordship may allow him to submit subject to outcome that part also.
No, because allowing him to submit
Then
means
other
there is no
person-
information to
And
others.
other persons also there.
That is the problem.
No, no,
Otherwise, I would have.
So Lordship, is
Because there seems to be, you just give us that.
Lordship may indicate in the my lord's order itself that how we can overcome 4.1.2. That part Lordship may some clarification from our side. Lordship may indicate that part.
Or can we say that the next date, the interim order would be passed in, that the interim order is such that I extend the bid submission date to 22nd. If that is there,
Lordship.
then on 28th, if you get me the instructions, we can go ahead with it.
Lordship.
How do you say? Then it will be enough notice to others also.
Lordship.
Because by way of a corrigendum, you can very well extend the,
Lordship.
so thereby I'm not staying the tender process,
Lordship.
only extending the process.
Lordship.
I think that is a more better than
Lordship,
staying the
then
process.
everything will be Lordship.
I think everything will be remain as it is,
Lordship, Lordship.
only the period of extension,
Lordship.
bid submission is extended.
Lordship. Lordship may submit, then my lord may fix on 20 and Lordship may also put a query regarding that part.
Yes, I am putting it.
Lordship.
How no, the only reason I want is how do
Lordship.
you
Overcome that.
gel both together?
Lordship, that part, only that part.
Sir, I have nothing. Then Michigan takes it.
Lordship, only that part. Otherwise,
Presently, we are the supplier, madam.
Huh?
At present, we are also supplying, madam.
Presently, now they want people who, bigger people. I think this is a
look, this is the best way, Lordship, best way, Lordship.
because then the others also, the moment they issue a corrigendum
Lordship.
by tomorrow or day
Lordship.
after, then people will also know to
Lordship,
participate.
Lordship.
So
Then,
you may reject it later on,
Lordship, they can also.
but they cannot, but I allowing him to participate
Then
today
other
will
will,
affect
other
the
will,
others.
other will deprive. So Lordship may that will.
And the petition is for one.
Yes, madam. Anjali, we are ready.
Issue notice making it returnable on 28/2025.
20.
Pusto. Mr. K. Gogoi accepts notice on behalf of all the respondents,
Also, only 2 respondents, all the respondents.
on behalf of the respondents numbers 1 and 2. Pusto. At the outset, extra copies be served upon him during the course of the day.
Yeah.
At the outset, the learned counsel appearing on behalf of the petitioner
No.
submits petitioner submit that the petitioner number one, that the instant petition, that the petitioner number one would not like to further pursue the present proceedings.
But two, but
Oh, no.
petitioner number two doesn't want to continue.
Petitioner number two, he submits that taking into account the taking into account the cause of action being different, the learned counsel for the petitioner, at the outset, the learned counsel for the petitioner submits that taking into account the respective causes above, this court strikes out, permits the petitioner number two to withdraw the instant petition and further grants the liberty to the petitioner number two. And in that matter, the name of the petitioner number two is struck off. The counsel for the petitioner is directed to file a fresh memo of parties before the registry of this court on or before 18/8/2025. And the registry of this court shall, on the basis of such, the basis thereof, the present order, make necessary changes in the cause title and update the same in the CIS. Full stop. The case of the petitioner herein is that the petitioner is an MSME registered under the MSME Act 2006. The certificate of the petitioner have been enclosed as Annexure 1A to the petition. The grievance of the petitioner is on account of the additional terms and conditions, what is on account of clause number 4 of the additional terms and conditions dated 6/8/2025. Insofar as the notice inviting tender of the same date pertaining to the supply of dietary articles under Zone 5 jails of Assam during the financial year 2025-26. The learned counsel appearing on behalf of the petitioner draws the attention of this court to clause, where is that again?
Case 201,
Clause
4.1.
4.1, which stipulates the evaluation criteria and methodologies. In terms with the said clause, and more particularly clause 4.1.2, it was mentioned that there would be preference, there would be preference granted to the micro and small enterprises by the department, state public sector undertaking and its aided institutions. The learned counsel appearing on behalf of the petitioner drew the attention of this court to the Assam Procurement Preference Policy 2021, notified by the Governor of Assam, dated 6/12/2021. whereby in terms with the Micro, Small and Medium Enterprises Development Act 2006. The government of Assam had streamlined the mechanism for procurement of maximum goods and services by various government departments of the PSUs of the state government from enterprises of the state without compromising quality, competitiveness, and cost effectiveness. The Learned Council refers to the definition of micro industries and enterprise as stipulated in clause 3 Roman 1, wherein it is mentioned that to be a micro enterprise, the investment in plant and machinery or equipment does not exceed 1 crore and the turnover does not exceed 5 crores. First, the Learned Counsel for the petitioner further submitted that in terms with clause 4 of the additional terms and conditions, the tenderer has to submit that it has minimum average annual turnover over the last 3 years of rupees 11 crores. The Learned Counsel appearing on behalf of the petitioner that there appears to be a discrepancy in the tender notice in clause 4 of the additional terms and conditions in as much as the same is not in consonance with clause 4.1.2 of the evaluation criteria. The Learned Counsel for the petitioner further expanding his submission submitted that if a micro enterprise is required, is given or submitted, that on one hand, there would be a preferential procurement in respect to a micro enterprise whose average turnover cannot exceed 5 crores. But on the other hand, the respondent authorities have made it an eligibility criteria to have 11 crores as the average annual turnover for the last 3 years. He therefore submitted that the petitioners who otherwise is entitled in terms with clause 4.1.2 of the bid document as well as the Assam procurement policy, preference policy 2021, is being debarred by a condition as mentioned in clause 4 of the additional terms and conditions. First, Mr. K. Gogoi, appearing on behalf of the respondent numbers 1 and 2. Now, first, in that view of the matter, the counsel for the petitioner submits that the tender process is required to be interfered with. The clause 4 of the tender additional terms and conditions is required to be interfered with. And further, the tender process required to be stalled, taking into account the last date for submission of the bid is on 16/8/2025. Mr. K. Gogoi, appearing on behalf of the respondent, submitted that he would require to take instructions as to whether there is a discrepancy between clause 4.1.2 of the bid document along with clause 4 of the additional terms and conditions. He, however, submitted that a matter requires an urgent resolution, taking into account that if there is a delay in awarding the contract, it would lead to disruption in the supply of dietary articles under Zone 5 jails of Assam during the financial year 2025-26. He therefore submits that he would obtain the instructions and place before this court on the next returnable dates so fixed. First, this court have duly taken note of the clause 4.12 of the bid document, as well as which is the eligibility criteria, as well as the Assam Procurement Preference Policy 2021. This court further have also perused clause 4 of the additional terms and conditions. First, prima facie, it appears that there are certain discrepancies, in as much as on one hand, the micro enterprise is being permitted. It would be on one hand, the micro enterprises are being given preferential treatment in view of the Assam Procurement Preference Policy 2021. And on the other hand, the said micro enterprises, by virtue of the definitions contained in clause 3.1 of the Assam Procurement Preference Policy 2021, is permitted. It cannot exceed the annual turnover of 5 crores. Full stop. On the other hand, clause 4 of the additional terms and conditions mandate that rupees 11 crores shall have to be the annual average turnover for the last 11 years. So considering the above, this court therefore is of the opinion that the petitioner has been able to make out a good case for passing certain interim directions. Next, this court accordingly therefore directs the respondent authorities to produce the instructions as to whether there is any discrepancy between clause 4.1.2 of the bid document, which is the eligibility criteria, with clause 4 of the additional terms and conditions. This court further, this court also is of the opinion that the matter requires an urgent disposal. This court further directs the respondent authorities to extend the date of submission of the bid docs to any date on or after 22nd of August 2025 by issuance of a corrigendum in the meantime.
My lord, may the order lordship micro is written lordship. My lord may indicate micro small enterprise. Small is also there lordship. MSC.
We are concerned with small is different definition.
MSC lordship.
Minor, 3 to 4.
Now understood, micro and small enterprise, you see the definition here,
Lordship.
small is 10 crores.
Lordship.
Micro
Here
and
difference is given lordship as
to
per
micro
clause-
and it was micro look at small guy. Small. We'll put it small.
Lost.
You are micro,
Micro.
lordship.
but it has the effect of micro.
Micro,
small.
so that's why lordship.
Micro and small. So he's micro, so we go by micro,
Lost,
but
lost.
you get the instruction for small also.
Lordship.
It will have the same impact.
Same impact.
Same. So we have asked you to have it on or after 22nd of August.
Lost.
Issue a corrigendum.
Lost.
I have not said on
Lost.
22nd, but I leave it to your liberty, on or after.
Lost.
So you do
Lordship,
it.
my
28th.
pair is that my lord, if lordship may supply one copy today itself, then I can lordship.
He's going
No,
now.
no, lordship, regarding my lord's order copy.
Oh, order.
Lordship.
The order for the true copy of this order be provided to Mr. K. Gogoi by the court master of this court, so that the information of this order is duly passed on to the respondents.
For admission, item 1, daily list.
My lord, letter pertains to my lord, non-consideration of appointment to the post of.
Reply 5.
Lordship,
Now what is your case?
they've already filed their reply.
A matter has come up from before me for the first time.
Yes,
What are you challenging?
I'm challenging, my lord, although there are two clear vacancies, general class, my lord.
Appointment
And
of the
I-
petitioner has not been considered for appointment. As to why appointment has not been considered for appointment to the vacant post of LDA copies typist for the district judiciary in spite of obtaining two highest marks in pursuance to the advertisement dated. What is left now? Yes, what is left?
No, two posts advertised, that was a wrong done on the part of the authorities then. Because when, before filling up the vacancies, it was found that actually there was only one vacancy.
Ah,
So that's why, my lord, one appointment was made, my lord.
so somebody has been appointed.
Yes, my lord.
Now
Not-
there is no
Actual
vacancy.
vacancy was only one, so that's why one
And he was not put in the wait list. Where's the select list?
My lord,
select list, my lord, will find.
select list page 19, lord.
What is your
Page
name?
18. My name,
Relevant portion.
my name, that's serial number 2, man.
In which district?
My lord, Karimganj,
Page,
18, annexure 4, lord.
yes.
Petitioner secured 88.5%, my lord. He secured second position.
Karimganj only one post,
One
page
post,
25.
STH,
Where, ma'am?
and STH was appointed, your lordship will find page 25.
Page 25 is.
Yes.
No, no, it is the select list, my lord. Only one person, that is my lord STH,
Ah,
my lord, Sina Valian Chore, only he was appointed.
then
He becomes to HTH only, and I am the general category candidate.
how many posts were advertised for
For
it?
general category, 2 posts are there.
Where
It
is
is
the
very much clear from the
advertisement?
advertisement. If lordship may kindly come to page 10, my.
Page 10.
Advertisement starts from page
Two
9.
posts.
Relevant is page 10, serial number 15.
Post 18. Karimganj 2 posts.
Yes.
One
unwritten.
is general, 2 are general layman. Now what has happened? Why you have not considered what is Karimganj thing? What has happened?
My lord,
There were no vacancy.
no vacancy, my lord. Actual vacancy was only one.
Now what do you say, page 31? It is of the year 2020.
2000.
When did you file this petition?
In the year
What is that?
2020, my lord, immediately after receipt of the RTI application.
No, this
RTA.
There is a
vacancy,
clear cut vacancy, my lord.
This Iman district, name of the post LDA, 3 vacancy position as on Iman 3 with effect from Iman. General 2, 1 OBC reservation.
this vacancy
We are
position was
on
after.
which post?
LDA copies and typist, my lord. This was a combined examination.
LDA.
For general 2,
Anticipated vacancy existing and anticipated of LDA. Now here will be considered for all LDA.
These were after the advertisement.
So as on 27,
Advertisement dated, my lord, 13/11/2018.
huh?
Advertisement is dated 13/11/2018.
Oh,
So
as
as
on that date, there was no post.
There was only one post for reserve for STH.
STH. So
Which-
these came later on.
Yes, which we could found.
Now, have you then held any vacancy filling up of?
Thereafter, my lord, there are centralized recruitment held, my lord. After 2018, 1920, my lord, there were centralized, perhaps this post would have been filled up in the subsequent
Petitioner
recruitment.
did not get.
yes,
My lord, that instruction I don't have.
no, my lord.
The UST,
At present, I don't have any instruction what is
you are
actually doing.
J,
My lord,
are you J judicial assistant?
no, no,
No, no.
Below that,
Copies
He
typist
applied-
LDA.
LDA.
no, no,
Office and
LDA,
type.
below the LDA is what post? Is it promotion or what?
No, no.
No, direct recruitment.
Direct-
Direct recruit?
Yes.
Okay. So there was no post.
There was
Then-
no actual vacancy, there was only one.
Vacancy statement at page 6 and 7. What is the vacancy statement? LDA 1 junior assistant, number of post on 18 month. Total sanction post, unreserved 1, LDA 1. Copist 1. He applied for what? Copist.
My lord, it is a combined examination. LDA typist copyist. Wherever I am found suitable, my lord, I am.
Then why, what do you do about this thing? Annexure 1, unreserved,
Yes, my lord.
page 6.
Yes. But page 7, my lord, will kindly have.
Hmm.
And-
3112. This
and-
is for the next 6 months.
Yes, my lord.
But here, what do you say about one,
my lord will,
here, one junior assistant in Kutsi Iman?
My lord will kindly have page 30.
MSc.
page 13 for a moment, my lord.
Page
Page 11 and 13, my lord.
of,
This was the, of the affidavit.
no, 11, 13. this.
Page 11, annexure 3, my lord.
But 3.
Yes.
Yes. Now, what is this? Again, different?
There was only one post of STH.
No, this is in the year 2019.
Yes, my
But
lord.
what do you say? We are concerned with this one now. Page, as on the date on which they
There is,
advertised.
it is showing one post. It is showing one UR post. But even then, he is at serial number 2.
How do you know?
He, in the select list itself. it is-
Show me. Where is the select list?
At page 18, lord.
Page 18.
Of his affidavit.
No,
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 the
read
writ
petition.
petition.
In the writ petition, page 18. Oh, you are number 2.
Serial number 2, my lord.
Then how do you get it?
88.5. In advertisement, lordship, it is very much clear, my lord, that in the district of Karimganj, there are 2 unreserved vacancies. And one post is for ST Hills, my lord. They have appointed only one, they have selected only one post, that is ST Hills. And both the general, my lord, vacancy, they are kept vacant.
But you are number
No one is selected. my lord.
number 2. How do I help you?
There are two
But
vacancies.
there was no vacancy as on that day.
It is their contention, my lord, that there is no vacancy, but my lord, if it is, if lordship may kindly go through my
But
RTI application,
but you
reply, my
show
lord.
me the vacancy position as on 18/8/2018. The date of the applicant,
The date of advertisement.
any document.
The date of advertisement, actually, my lord,
Or 6 months thereafter. 6 months, not
yes, my lord,
because the anticipated vacancy will be 6 months thereafter.
yes.
In fact, the anticipating vacancy on 18/8 will be as on 31st of December 2018, isn't it, Mr. Das? Because as per the rule 6 will come in. The district judge is required to look into all the anticipated vacancies for the year. Which means it will by 31/12/2018, how many vacancies are there as per you?
In fact, in the affidavit also, we have
Because the
stated,
document which you have enclosed only shows as on 27/6/2019. That won't help you.
What is the actual vacancy position on that particular date, my lord? I may be just seeking some information because
I think
I have the vacancy position of 20 and 21, 5 to 20.
Before 12 o'clock, your matter should with the judgment. Now tell me, I'll give you another 5 minutes. My only query to you is this, where show me a document that has on 31/12/2018. There were 2 vacancies of general. That's all. LDA or books. Show me that. If you can show me that. If you don't, no.
My lord, on advertisement, my lord.
I
it-
can do one thing, public service, that post should have been filled up in favor of Chandana Roy. If you want to do something good for
My
people.
lord. My lord, advertisement was published on 13/11/80.
Advertisement, they may do anything, but does it give you a right?
Whether on that particular day, there was a vacancy or not.
And therefore, I'm not saying on that particular. I'm giving you here.
Thereafter 6 months also.
2018. But Chandana Roy appointed.
That instruction I don't have, madam. Perhaps,
Because-
maybe,
The why I'm saying they're
Going by-
These to exist from 3/2019.
correct, correct. And in the 2018, that page 6 also, it shows that one UR vacancy is there. So perhaps we may have,
You are in there, so as on 3/2019, which is page 7
yes, my lord,
or page 17 or whatever 18,
yes,
there is nothing. You see here, page 6, one UR is there on 18A.
yes,
Then you see that 31/12/2018, no vacancy.
yes,
So this is the document at page 7.
yes, man,
So from this document, it says, I think Chandana Roy must have been appointed.
yes, that is also my understanding.
So we start.
Or let me verify, my lord, whether there was a vacancy within the 6 months.
You actually made the mistake. You filed this writ petition at the peak of COVID.
Yes, yes. It
So
was,
you didn't have all the information. And the COVID effect must have been such that even after filing of the affidavit, which was on 9/4/2021, because from 16/4/2021, there was again COVID wave,
yes.
the second wave. So again, you had the COVID must have been the disastrous consequence. Hello, heard Mr. So the learned counsel appearing on behalf of Krishna, Mr. H.K. Das appears on behalf of the respondent number
Respondent number, my lord, 20.
The petitioner herein to agree by the actions on the part of the respondent authorities in not appointing the petitioner to the post of LDA.
Yes.
Public copyist.
LDA copyist typist. Public.
You are not typist.
No, no.
It's to the post of LDA public copyist, public typist in the district judiciary, in the establishment of the district judiciary of Karimganj, wherein the petitioner applied in pursuance to the advertisement dated 13th November 2018. First of all, the case of the petitioner is that in the advertisement dated 13th November 2018, it was notified that there were 3 vacant posts to the that the advertisement. There were 3 vacancies to the post of LDA, public copyist, public typist in the establishment of the district judiciary of Karimganj. So out of the 3 posts, 2 posts were unreserved and 1 post was reserved for scheduled tribes hills. The petitioner participated in the selection process, and amongst the general category, the petitioner, who is a general category, belongs to the unreserved category, participated in the said selection process, and he was adjudged as and as per merit, he secured the 2nd position after one Chandana Roy, who secured 90.5 marks as against the petitioner securing 88.5 marks. The grievance of the petitioner is that the petitioner thereupon was not appointed, and as such, the present petition had been filed. The council, the respondents have filed the affidavit on 9th of April 2021, wherein details have been furnished that as on 18/8/2018, the total post, the vacancy position in respect to LDA oblique typist or typist, oblique typist, in respect to the unreserved category was only one. And there was another post in respect to the scheduled tribe hills. Vacancy in respect to the scheduled tribe hills. Full stop. It was further mentioned that as on 31/12/2018, there was no vacancy in the district judiciary of Karimganj. It is therefore the case of the respondents, as could be found out, as could be seen from the affidavit, that in the advertisement dated 13/8/2018, it was wrongly mentioned that there was two posts required, there were two vacancies in the unreserved category in the district judiciary of Karimganj, which should have been only one post. This would have heard the learned counsels appearing on behalf of the parties and have given an anxious consideration to the pleadings on record. From the materials on record, it transpires that though the advertisement was in reference to the advertisement dated 13/8/2018 stipulated that there were two posts, two vacancies in the unreserved category. But in effect, as for the vacancy position shown in the Annexure 1 and Annexure 2 of the affidavit filed by the respondent, the vacancy position as on 18/8/2018 was one unreserved post of LDA oblique copies of the typist and one reserve post of STH Hills. It is further seen from the vacancy positions as on 31/12/2018 that there was no vacancy as on that date. Considering the above, this court also duly takes note of the settled principles of law that merely being selected does not give right to an appointment. In view of the above analysis, this court therefore is of the opinion that the petition has to fail, taking into account that as there was no vacancy, failed on the ground that the petitioner in the merit amongst the unreserved category had secured the second position and therefore had no entitlement to be appointed to the post of LDA oblique typist oblique copyist, to the single post of LDA typist oblique copyist in the unreserved category. Accordingly, the writ petition stand, this court finds no ground, no merit in the writ petition. The writ petition accordingly stands dismissed. In time orders, if any, stand to be. You finish before 15 minutes.
Take care.
Affidavit in opposition not filed.
File, my lord. We have file.
When?
It was filed on, my lord. 19 March 2025.
Huh?
19 March.
No.
Yes, 19 March.
Not filed.
Huh?
Why will they, on 15/5/2024, you say 3 weeks time to file affidavit?
No, that time I am not there.
Thereafter, you have not filed.
19 March, my lord, 25. Hey,
This one.
actually, the advertisement was silent and probably there is no stakeholder
I
was.
have passed some judgments, no?
Yes, actually, in that case, my lord, their qualification, my lord, but here the advertisement silent, my lord.
Understood.
Other judgment, my lord?
I passed some orders also.
Yes, my lord, in various order, my lord, but
Do you have any?
yes, my. Hmm. Right, no? That is some over qualification, some under qualification, my lord. But here in the specifically, the notification has been silenced.
Where is Mr. H.K. Das? He has some orders. I passed some on. In respect to this, because there was a challenge made. And then a review was filed. I still remember. What had happened? Mr. D.P. Bora, D.P. Bora, he appeared
Yes.
in respect to a matter where he was not inclined to do the matter. Mr. H.K. Das, you
this is the-
remember one matter?
This is the judgment. He has given,
It
yes.
was a very funny matter. Mr. D.P. Bora, he did not want to do the matter. Then
That is
I
a-
said, okay, you don't do, but as the matter is fixed, I'll take it. He said that I've handed over the file. Then the matter was taken up and then I found out this particular person was appointed beyond the eligibility criteria. I interfered with that. Then a review was filed by Mr. S. Buragohai. Remember? And I dismissed it, giving a detailed reason as to why it cannot happen, because the fixed. Yeah.
Yes.
And then a review was filed.
So
So
review
the
has been-
review having been filed, I made it clear there in that order. Huh? There's a review also filed.
Yes, review by, I appeared for the.
Yes, you appeared, I remember.
Yes.
Then he said that I'm appearing. But,
But here in this case, probably, my lord, they are challenging the advertisement and they are eligible.
okay, the
But
same
my
thing,
lord-
no. There, in the review, they gave the color of an challenging the advertisement.
Oh, yes, but in that, the judgment, my lord, that DP Bora appearing, my lord. In that case, my lord, that advertisement or my lord, that notification is not challenged.
So there in the review, they challenged.
Oh, yeah.
I could have dismissed the review on that, but I also went further and said that it could not have been taken into account. The advertisement categorically mentions on the basis of.
Because he was overqualified. Here also he was overqualified, but.
No, not overqualified. There was two notifications. He was saying that there was a notification of 2016,
16.
which was only for the High Court. But there is another notification of the year 2021.
21.
Very good. See?
There's annexure 4, my lord. Here in this annexure 4 here, my lord. Of writ petition. Page 19.
Yes, this one. That
Yes.
shall also apply.
But here probably they lost interest because there is an interim order was refused. I have seen, my lord, on interim order was not granted.
I do one thing. None appears on behalf of the petitioner on call. Mr. T.J. Mohanto, the learned senior counsel, who is also the standing counsel of the Guwahati High Court, assisted by so-and-so, appears on behalf of the respondent numbers 1, 2, and 3. The issue involved in the instant proceeding pertains to a challenge to the advertisement dated 24/9/2021, whereby the eligibility criteria have been mentioned for the post of
Peon.
peon as class 8 pass, but class 12 not passed.
Not passed.
Post- There is one judgment which was there, although there was a division bench judgment of the Supreme Court, then there was another 3 judges bench of the Supreme Court. Wherein it says that they have the right to sue. You see that in various judgments passed by this court, the notification number 1 dated 4/1/2021 have been upheld. The advertisement dated 24/9/2021 is a consequence to the notification number 1 dated 4/1/2021. Under such circumstances, this court does not find any merit in the instant proceedings for which the writ petition stands dismissed.
Item 3,
N. Pandit, the Learned Council, H.K. Das, submitted by the Learned Council, the Women Office of Finance, they have here. What is this challenge here?
Lordship, the petitioner Lordship, she is presently working as in a grade 4 post in the establishment of SJGM Gosaigaon. She was appointed on 3/9/2011 and she is getting a fixed pay of 9,000. The prayer of the
So he needs as per Upendas.
Not cover, my lord. She was engaged in 2011. Will have to be,
Upendas do not come in.
will not have.
Neither Jagjit Singh come in.
No. Only thing, my lord, so far as my instruction says that, my lord, 9,000 is the last revision made regarding, my lord, fixed pay. Thereafter, Upendas came and, my lord, new notifications were issued. So last is 9,000 she is getting.
Now he wants regularization.
And of course, will not come.
and there are lots of communications
Mr. Council, how long you have been working?
from 3/9/2011.
You've submitted representation.
Lordship, may kindly see page 25, Annexure 8 college. There are also communication
Annexure?
from the page 25. They have a request to create a post, Lordship. Because there is
You are a sweeper.
yes,
How can you be regularized?
grade 4 post.
Grade 4 sweeper against the government policy.
Yes.
No case.
But in this communications also, this has been written that
Whether
to
you apply for various posts,
fill up new 3 permanent posts.
huh?
This this is for the prayer has been made for creating 3 new posts, permanent posts by the SDGM Gosaigaon.
So
Then-
apply as
then
per
there
the-
is- there
as
is one
per-
more-
As per the, yeah, looking for the advertisement. Well, you see, the question of regularization has to be to that same post. Your post has to be, that post cannot be regularized because I think the sweeper is outside the,
Yes.
outside the purview. How do I help you?
Even for regularization, my lord, this is a personal post, not against the sanction. Regularization will be against the personal post, not against.
Personal post. So you cannot, there cannot be a regularization to that post, it goes against the government policy. And as regards minimum scale of pay also is not permissible. In view of that, you don't follow within Upendas. Upendas is 2006 plus 10 years, isn't it?
Yes.
And that was also a consented order,
My lord.
isn't it? What are you showing me?
Upendas on that. para.
41.
Yes.
Writ appeal 41.
Yes. The para 22.
Para 22 lots of
Will
minimum.
not
of the
cover.
fiscal lots.
No, it will not. cover.
That case.
Not covered lots of, let them then file an affidavit lots of, I mean, let them file their affidavit lots of.
Why?
And because there was on the last occasion, they are supposed to issue a produce office communication logs, office memorandum,
What?
as per the last order also,
What?
and to file a counter. So that I can respond to it.
Basically, law point, my lord, whether it will be covered or not. Specific relief is my lord Upendas.
Mr. Here you must be having it, wherein categorically say that in respect of sweeper post, there cannot be.
Yes, that part I have, my lord, but right
I
now.
think you have it.
Well,
And Lordship, there is one more communication, page 26, may kindly be seen, Lordship. Page 26.
Outsourcing and SME report.
That is a different thing. Is there no relief? Whether they create or not, that is absolutely within the administrative domain of the district judiciary and the high court. Or the high court and the government. We got it?
Oh, my lord, that is not with you. I can finish, my lord, after some time.
You should carry that tab, which Mr. Arbor Pujari does. Be more tech savvy.
My.
Yes, than carrying these papers and all. He has all notifications in his small tab. But are you getting the 9,000?
9,000 Lordship, I am working and I'm getting 9,000 Lordship.
Apply for that whenever the post comes.
Yes, my lord, whenever advertised, my lord, the experience may be counted, that
That
can be
will
done.
be counted. That will be counted.
Yes.
But the question is here, it cannot be. You withdraw.
Lordship, let me check that office memorandum, Lordship, I also.
No, I know that. I've seen it and many times say he will produce him with you. And why I'm saying it, if I dismiss it and there is no question of regularization, some chance you may get somewhere, you may lose. But the sweep, as a sweeper, you cannot get regularization. Possible.
Lordship, the minimum pay scale, Lordship, I'm just praying for minimum pay scale.
Minimum to more, not possible. That is in view of Upenda's that paragraph. And that was a consented order where the government
Yes.
said that,
Yes.
okay, look here, we are going to. do this.
There are 22.
There are 22 Lordship, I'm holding Lordship.
See, so just before that, before the direction which is being given in Upenda,
Yes.
as regards those regularizing them, prior to that, there is also one paragraph wherein it says that the government have agreed to, isn't it?
Yes, ma'am.
Read that where Mr. D. Soike agrees.
In the last line, my lord, final direction was made that the minimum should be paid.
Read that order and
And Lordship, there is a review petition pending against the Upendra Singh. And notice has been issued, Lordship.
No, review, no. Withdraw, no.
yeah. It is however heartening to learn that the state government has agreed not to terminate the master roll layup and similarly placed employees retirement except on disciplinary ground or demand. Has also agreed to enlist such employees in the health and accident demand, health and dental scheme which will be prepared in so and so. We appreciate the positive stand of the so and so. We accordingly direct the state government to implement the measures without further delay. Besides this, we are in the light of so and so direct the state government to pay the minimum of the state wage to RIA workers and similarly place employees working since last more than 10 years, not in sanctioned post with effect from 1/7/2017. 17.
Yes, ma'am.
So it will go back 10 years.
Yes,
Prior to
2017.
1/8,
It will be 7.
Huh?
7, my lord. It will be 2007. Sometimes in July 2007.
Anybody who has done from 1/8/2007
Yes,
to 1/8/2017,
yes.
they will come within.
No, my lord, it will have to be exactly from the next day of the order passed. Then it will be, my lord, 10 years. So it will have to be in 2007. July probably, my lord, the order was passed. July 2007.
No, this was passed in June, Lordship. 8/6/2017.
8/6. After it will have to be, my lord, from
The order was passed when?
8/6.
8/6/2017.
From 9/6 it will be counted, my lord.
9/6? This is the order of 2007.
No, 17.
Ah.
So if you go back, my lord, 10 years, then it will be in, my lord, sometimes in, my lord, 27 or 9/6, 9/6/2007.
9/6, 2007, anybody working?
Yes, prior to that or 9/6. Then, my lord, it will cover. 10 years will be over.
Anybody working prior to 9/6?
Yes, prior to 9/6. Then, my lord, all 10 years will be over by that time. All. After that, my lord, it will be 9 years or 8 years, it will be difficult again. This part, my lord, though this is under appeal, my lord, before the Honorable Supreme Court, one review was filed by the workers employees, my lord. He is not a, my lord, workers employee, present petition. Because they are enjoying some scale pay, workers employees.
Lordship, one review petition is pending against this judgment, Lordship.
No, that is filed by the workers employees, not by the master or contractual employees.
Lordship, I was working since 3/9/2011.
So how do you
Please,
get the
Lordship, there is,
minimum scale of pay?
Lordship, let me clarify that office memorandum, Lordship. I just want to check what's going. Lordship, may give me some time, Lordship. I just want to check.
Mr. Gogoi, why didn't you file the affidavit?
I can file that.
File your affidavit, you have sought for time earlier.
Lordship, I will bring that, my lord, particular
And
notification
bring
on
on
record,
that office member.
as well as the, my lord, Upendra's notification, whatever we have. Mine.
Because after that, there's AFRBM, they have
Yes.
done, yes, asking all the departments to provide all the details.
That I have, that notification I have in hand, but my lord, probably I will have to bring it
Now,
on affidavit.
What has happened to another case which I was looking into, means this Upendra's issue came to me only after almost 2 years.
My lord.
In the month of January, January to March or April, I was looking into a bench where I was dealing with pension area salaries and all.
Free, bench free, my lord.
No, that was a special bench.
Bench 5.
No. Pension, area salary, suspension, that
Yes.
bench was there along with serious matter. I was
Right.
dealing with this 4 months. Now that bench is no longer there. Then the Upendra's case, there was one case filed by Mr. A. Ganguly, I suppose. Yes. On the stenographers of the tribunals.
My lord.
Remember, you were appearing in that matter. Stenograph, they were asking for the same thing of the tribunals, but the issue which I was taking it up, that whether this, how Upendra's may have said that it is 10 years, how do you take care in the case of Jagdish
Yes,
Singh?
my lord. There, this 10 years, my lord. is
What has
not there.
happened to that, cannot dispose of? Because that
it
was
was-
the issue which may cover him. But there I was saying, Jagjit Singh says that anybody who was working
Yes,
and doing a similar work
yes,
to the other employees are entitled to the minimum scale of pay,
and
which is given to the grade 4 or whatever
yes.
maybe the
No, not
minimum
great
scale.
formula, similarly placed employees. So far as the present petitioner is concerned, he will have to
does
show.
not have any.
Yes, they will have to be a regular sweeper who is enjoying a regular pay scale and he is doing the
That is
same
your
duty.
problem, Mr. Council.
He
Their
cannot have
problem
that.
is- With Jagjit Singh, that is your problem. Because Jagjit Singh will only come there.
Yes, two sets of employees, one are contractual, one is regular. Same works they are performing. In that case, minimum pay scale. That is the existing case. my lord.
That is Jagjit. Here it was a agreement. This is an agreed consensus order, Upendra's. But otherwise, you can take the help of Jagjit Singh. But how do you take the help of Jagjit Singh in view of you don't have a counterpart?
Yes,
You
in
see
the same
regulator.
institution or establishment.
You bring that
Man,
aspect
Lord.
and file an affidavit in that.
Lots of,
Because there cannot be a counterpart there.
lots of.
It is seen that though the finance department sought time to file the affidavit on 3/1/2025, and produce the office memorandum issued by the said department, but nothing has been done in that regard. To list this matter again, on 18th of September 2025, the affidavit as well as the affidavit be filed by the finance department without fail. It is observed that failing to do so, this court would be constrained to pass appropriate orders in the writ petition on the basis of the materials already available on the court.
Obliged, sir.
Item 4,
Yes, Mr. Sharma.
Lord,
Yes, has your person got the electricity or not?
my lord, the order was made available yesterday. In fact, the petitioners have been made aware of the order of this honorable court and will be filing their applications, my lord. In the meantime, as I understand, the APDCL authorities tried to intervene and provide connection. Respondent number 5.
I think by the time the matter reaches this court on next week,
Yes, my lord.
next week, I
Yes,
think
Monday, my lord.
it will become infructuous. Yes,
I hope so. Yes, my lord.
now come.
Yes, my lord. My lord, this petition, I'm in a very narrow ground, my lord. Here the matter is for reinstatement of the petitioner from the date of his suspension. The suspension order, my lord, is at page 16.
Oh, this one.
Yes, my lord. In fact, my lord, there was a query. There were 2 queries that your lordship had
This
posed.
court, having perused the materials on record, finds it relevant to observe that the inquiry officer did not hold that the petitioner had forged document.
Yes, my lord.
Rather, on the ground that the petitioner was negligent and his actions were unbecoming of a government servant.
Yes, my lord.
And the said inquiry officer having been accepted,
Yes, my lord.
the petitioner was dismissed from service. It is also relevant to take note of neither the inquiry report nor the dismissal was on the basis of the conviction against the petitioner at that relevant point.
Yes, my
The
lord.
question therefore arises as to whether after withdrawal of the writ petition earlier, can the petitioner now maintain the present writ petition?
My lord, that order of withdrawal, it's a single page order, my lord, at 135. Now, the reason, my lord, is that this order of withdrawal was passed on 10/12/2023,
Page?
page 135, my lord, the affidavit in opposition, my lord.
Ah. A. Bogore, Lalit Council submits that the petitioner has been
The petition be dismissed as withdrawn.
withdrawn. Accordingly,
The petition
it
is
is
dismissed.
dismissed.
Now, my lord had posed a query whether on the occasion of that withdrawal of the writ petition earlier, can the writ petition, this made writ petition is maintainable. My lord, this present writ petition has been based on the judgment and order dated 21/11/2023, which is pursuant to the order of withdrawal. My lord, it is in a humble submission that the order and judgment and order dated 21/11/2023 has given rise to a new cause of action, right or wrong, that your lordship will decide. The reason being that in the judgment and order dated,
No, you have accepted the inquiry report.
my lord, the inquiry report has been accepted.
Therefore,
Yes. Yes, my lord.
the formulation at paragraph number 6 of my order makes
Yes,
it
my
very
lord.
clear
Yes,
that look here, the inquiry report is not based upon conviction.
yes,
The inquiry report is not on the basis of a forged document.
Yes.
Because the criminal proceedings were on the basis of a forged
forged
document.
document, my lord. Yes,
Inquiry was not on the basis of the forged document.
Yes.
The inquiry was you have acted in a manner unbecoming of
Unbecoming.
an officer.
yes.
And you have accepted the inquiry report when you withdrew the petition. Can you now agitate the issue?
Yes, my lord. My lord, now, subject to, my lord, this honorable court's final orders, my lord, this writ petition has been based, right or wrong, my lord. In fact, what has happened is that the disciplinary proceeding outcome, it preceded the conviction and the final acquittal. The suspension, then dismissal, it preceded the final acquittal of the petitioner.
Final?
Acquitted. The petitioner was acquitted. Now, this petition, my lord, there was this recent judgment of the Honorable Supreme Court in 2014, 3 SCC 636, Stenzen Toyotsu India Private Limited, where the finding of the Honorable Court that might not be applied retrospectively, my lord, but the finding of the Honorable Court was that if 2 sets of facts are very similar in a criminal and a disciplinary proceeding, it is suggested that the disciplinary proceeding be kept in abeyance if the witnesses, the PWs, are also same in both the matters. Now, the issue has flown from the same cause of action. This
Did you
writ-
raise that in that earlier petition?
My lord, that I'm not aware of, my lord.
No, you should.
I should-
Because that is
yes.
why I gave time to Mr. M.K. Chaudhary on the last
In fact, my
occasion.
lord, the earlier writ
The
petition was
last
filed.
occasion happened
Yes.
in the year 19/6/2025.
Yes, my lord. In fact, the earlier writ petition was.
We have passed 2 months.
Yes, my lord.
But you don't have the instruction.
My lord, the earlier writ petition was filed in the year 2007. That was before, my lord, so the contention of the Honorable Supreme Court's principle in the matter of 2014 may not have been incorporated in that petition. Now, my submission, my lord, is a very small
So
submission.
are you saying therefore
Yes, my lord.
that with the judgment of the Supreme Court being passed subsequently,
Yes, my lord.
a cause of action arises?
My lord, the
This
cause
goes
of,
against the very principle. I think there is, Mr. Das, there is one judgment, a very old judgment,
Sangyukta.
1963.
Sangyukta,
No, no.
Sarguja transfer.
No.
I'm sorry.
It's a very old judgment, 1963/64,
So-
wherein the Supreme Court said that a judgment delivered by a court would not give a cause of action.
Yes,
Because it will have a far-reaching effect.
no, absolutely, my lord.
Things
it will be a
that
never-ending
will
process.
become unsettled.
No, my lord, our cause of action, my lord, it arose,
With tea.
my lord,
You know a cause of action.
my lord, our cause of action that we
Your
have.
cause of action is subsequent acquittal. It will have far-reaching consequences.
My lord,
No?
our cause of action arose on a date which was after the date of withdrawal of the writ petition. Now I understand, my lord, that that writ petition had challenged the.
But therefore, I am saying
Yes, ma'am.
that why did I formulate that?
Yes, my lord.
The dismissal was not on the basis of a forged document,
It-
whereas the
it wasn't.
conviction
It wasn't.
wherein you were charged was on account of a forged document.
Forged document, my lord, as was
Not
printed in
the
the copy.
becoming unbecoming of a year. Kindly see that, therefore I put it out
Yes,
there.
my lord.
It's
Yes, my lord.
To this,
Yes,
the
my lord.
inquiry report
Yes, my lord.
as well as the year.
Yes, my lord.
So it makes it very clear that
Yes,
you have been terminated not for any other purpose,
Yes.
because your actions were unbecoming of a year.
Yes, ma'am. And the standards of proof are also different in two different matters, my lord. That is also, we are aware of that, my lord. In fact, the dismissal had happened independent of the conviction or the subsequent acquittal, my lord. That is also, my lord, these are the facts before this honorable court, my lord.
That's
These are the only facts.
not being able to satisfy this court on this fundamental point. When I put that question to your senior said, I'll look into it. And then he's nowhere to be found.
Yes, my lord. My lord, I'm here, my lord. I'm here, my, I'm representing my senior, my lord. In fact,
So he has put you, go there,
absolutely no, my lord. I tried to find a
face
way
the
out.
guillotine of the court.
No, my lord, I tried to find a way out of this matter, my lord. In fact, I understand.
Way out, therefore I formulated this point for you to go away, find a way out. You have not been able to. 2 months have gone by. How much? What is the age of the petitioner?
My lord, he's he's on the right side of 70, my lord.
Right side of 70.
Yes, my lord.
More than 75?
75 as of now, my lord. He's 75 as of now and mentioned that, in fact, the question that this is a very small question that the matter entirely raised on, when the matter was,
Have you submitted any representation to them?
my lord, as of now, no representation. In fact, representations have been dated, my lord, 2000, that are not after that, my lord.
Why you have not submitted? You see, you may have a more kinder judge on the administrative side than me on the judicial side.
in fact, in such matters, my lord, similar matters also came to me to be done before learned tribunal. What we did in that matter, my lord, after the acquittal, we submitted an appeal before the authorities that look here, you impose penalty upon me. Thereafter, a criminal case was pending, and in that case, we received acquittal. They may reject it, but the procedure followed is that, my lord, to inform the authority that I have got the acquittal. So kindly have a relook at the penalty imposed. That normally we do, my lord.
That has not happened pursuant to the judgment and order of acquittal matter. That has not happened. A lot of things have not been done in the matter in the matter ascertained, but that is what we have. my lord.
And his entire case in the writ petition is that, my lord,
The problem arises in view of that order passed at page 135.
Yes. Yes,
The
yes.
order makes it very clear one thing, that you have accepted the
left-
inquiry. report.
That I have left that challenge aside, and when that challenge remains,
You should say that there is a criminal proceedings pending.
yes,
So let my right be
Yes,
there.
yes.
I have nothing to
Yes,
do.
yes,
I've
my
been done out there, so let some liberty you have to do. Now, once that is being closed, you have accepted.
yes.
See the language of
Yes,
the order.
yes, my lord. And the inquiry report stands. Then the moment the inquiry report stands, the final order of dismissal is based on the inquiry report. That aspect I cannot argue before this court, my lord, because that part is settled. Now, just sidestepping your lordship's query, which is again the main roadblock in this matter, just sidestepping it, irrespective of whether the matter was closed or not, irrespective of the fact that the inquiry report stands or not, the judgment and order of acquittal is what this matter is, entire writ petition is based on.
No.
That the same set of facts.
yeah.
Yes, the same
You are
set of
basing
facts
it
here.
on that, but that was not the basis for
That
the
wa-
inquiry.
No, absolutely.
Even
At
that,
the
at
inquiry
that
report
point
was
of time, only a charge sheet must have been submitted.
Yes,
When
yes.
you were, or no, not even
Yes.
there.
In fact, the inquiry report is very clear that
Here I
the-
made it very clear. It is seen
Yes.
that the pursuant to inquiry report being submitted and the petitioner being afforded an opportunity, the penalty of dismissal happening here. Appeal review was filed by the petitioner, which was also dismissed.
yes, my lord.
Thereupon filed a writ challenging the inquiry report as well as the penalty so imposed. However, the same was withdrawn. It further appears the petitioner was initially convicted in a proceedings initiated by so and so. The said conviction was overturned by the criminal appeal by the judgment and remand, and it is under such circumstances. Now, you see, when the charge sheet was submitted, let us see. You were convicted in 2012
Yes, my lord.
after 6 years from your dismissal.
Yes, my lord.
So the conviction order cannot also be there. Case pertains to the forgery of order dated so and so, and the charge sheet as well as so and so obtained from the conspiracy and Iman and forged letters dated so and so. Pass the judgment and order convicting the Iman. Where is that charge sheet given? So there's not even a trial going on at that point of time, it seems. What was the case number? You will get a chance of, yeah.
Yes, my lord, is special case number 28 of 2004. Your lordship will find that at page 73, my lord. The first paragraph, paragraph number 2.
Judgment does not mention what judgment do you.
in fact, Miller, the CBI court's judgment is not part of the writ petition.
Yes, my lord. The
That
appeal-
should have been the part of the writ petition, in fact. Because it would have contained the details.
So what to do? You want the guillotine on this matter in your hand or in the hands of your senior?
My lord, I'll leave it up to your lordship. The facts are.
No, I am asking you, giving you a chance. They
Your
have in a very kind mood.
Your lordship will put the guillotine on me, my lord. Lordship will put the guillotine on me, but your lordship will let me live another 2 days, my lord.
Why?
So that, my lord, your lordship's query about the.
Oh, I have started when the matter is fixed.
Yes, yes.
If adjournment is sought,
No, no,
I'll
I'm not-
grant it very kindly, but cost is 10,000 rupees per day. So you want 10 days? 1 lakh
Unlike everything.
on the council.
No, no, my lord, your lordship will. I'm willing to
2
be
days,
put on the.
20,000.
No, my lordship, lordship can pass appropriate orders, my lord.
Argue. You have not been able to satisfy me with clause 5 or 6.
Yes. Yes.
The problem is that you have accepted it.
Yes. Yes.
You cannot reopen if there is a acquittal. More particularly, when the judge inquiry report is not based upon that.
Yes. Preponderance of probabilities and presumption of guilt, my lord, that those are two separate standards. In fact, the inquiry report still stands. My lord, I have to admit this, my lord.
See,
The
there is
inquiry-
one judgment of Justice Vishwanathan. You are referring to the 2014 judgment, but you see the judgment, I think, in 2024 of Justice Vishwanathan. I referred to in one case.
Lord Vishwanathan is my lord Ramlal.
Ramlal.
He is relying on Ramlal.
It's 2020.
24 1 SCC 175.
And
there
there
is-
is referring to 2014.
And
But there is
just,
subsequently another judgment.
my lord, prior, there is one prior judgment, perhaps that is that will be of your lordship's assistance. That is 2021 12 SCC by Justice Chandrachud. Lordship can have a look, my lord. Him Singh.
Yeah. Now, I have dealt with another matter
Yes.
where I distinguished this matter pertaining to Ramlal. And again, in one matter, I gave benefit in terms
In
of
fact,
Ramlal.
Ramlal on a proposition wherein charges, evidence were identical. And conviction was made, sorry, my lord, penalty was imposed on the basis of conviction.
For independence.
Hmm.
Independent.
Wait.
Prior in time.
Paragraph 31 onwards, 31, 37.
And this is a case of where he has been done on the benefit of doubt,
Mhm. Yes.
not
He-
an honorable acquittal.
Ramlal was based upon a fact wherein
He was
his,
honorably.
no, he was, penalty was imposed on the basis of conviction. So that's why honorable court came for the rescue that no, once acquittal, so same set of facts and evidence as well as charges. Here, my lord, in our case, my lord, facts are different
Here, the dismissal was in 2006.
because it was not based on the conviction. It was based on the conduct
And he accepted.
and he accepted.
Problem arises there.
Yes.
He accepted. Now, otherwise there would be a big problem, which I think.
Hmm.
If he, yes, the proposition that if a person is acquitted, is convicted on the basis of his conviction, then in that regard, he has to be reinstated. There's no quarrel with that because it is based on conviction.
It is true, but that also in Ramlal, if your lordship see, the Honorable Apex Court has taken care of that aspect very meticulously. It did not, it was not laid down as a general principle that whenever there is a conviction or there is a
Yeah,
penalty.
Ramlal judgment.
Yes,
2015.
Ramlal, my lord, the Honorable has, Apex Court has gone in detail in factual.
Ha.
So that the point can be narrowed down to only one thing, my lord.
Now here, you see,
That Ramlal to 9 nahi? Oh, bahari. 75, 2024, one SCC, 175.
so paragraph number 28 of Ramlal has a contrary note to what was held in Bhim Singh. Bhim Singh, na?
Him Singh, yes.
Because Bhim Singh gives gives an idea as regards if a person is honorably acquitted and benefit of doubt aspect is being brought in by Bhim Singh. But however, in Ramlal, says that these are connotations which have no bearing. But in Ramlal, the court went
Go. Huh.
still into the facts.
Exactly, my lord.
as
That is
to
what.
whether a case can be made out
Exactly.
of any fraud.
Exactly, my lord. That is what I wanted to convey, that it's not an universal, my lord, principle,
Here,
just
I can
one.
say it is very clear that the relevant and material evidence being the deposition of PW5,
Exactly.
the mark sheet of exhibit of class 8 of the appellate, and the original mark sheet independently marked as exhibit by the defense have been completely left out in the discussion and consideration. Inference has been drawn about the proof of charges by ignoring crucial relevant elements. In this scenario, we are inclined to accept the explanation given by the appellant that overwriting in the application form was only due to correction of an inadvertent error, as long as the original 8 so and so reflected his day.
Basically, Honorable Apex Court has.
Mr. Das, with due respect, would it not be too fine going into the details?
Basically, what the Honorable Apex Court has done,
They
Apex
have
Court has.
far-reaching consequences, don't
I
you
understand.
think?
That's
This
why.
means when you are exercising, here the Supreme Court was exercising an appellate jurisdiction under 136 and then a leave being granted, it takes the flavor of, was it a leave granted or not? Leave being granted, it takes the flavor of a civil appeal.
Correct.
Appellate.
Correct.
But the appellate jurisdiction is against the certiorari jurisdiction. But the certiorari jurisdiction, if we see the Bhikartan Das judgment and all, there is a very
Correction of error.
nuances out there, the manner in which you are going to look into is only the decision-making process.
Only one thing that I have in my mind, Miller, after reading the judgment, basically the Honorable Apex Court gone into the question of perversity while because your lordship will see that the Honorable Apex Court has dealt with the evidence.
And in detail,
Whether
including his defense.
whether those evidence are relevant evidence to come to a conclusion of guilt of the person concerned there in Ramlal in a departmental proceeding. So apart from this, my lord, acquittal in the criminal case business, the Honorable Apex Court also gone into the aspect of perversity in the evidence recorded during the course of the inquiry and finally derived conclusion that no. So the element of perversity is also there.
The Apex Court has obviously jurisdiction under 142.
No, even in 226 also, lordships has got the power to see the perversity.
The perversity is okay. Perversity is okay. Perversity has, it's a case of perversity, then it has to be writ large.
Exactly. Correct.
Meaning thereby on the face of it, it should show that there was an error or the evidence was not taken into consideration.
And
Well,
also
here the
whether,
Supreme Court
whether-
says, we are inclined to, here it says, settle that if the findings of the distributor are arrived at after ignoring relevant materials, the court in judicial review can interfere. No quarrel with that. So here the court went into the question of perversity
yes,
of the findings.
exactly.
So therefore, and held it so. But if it is a perversity, obviously, there is no quarrel. There is a perversity, palpably erroneous, or without jurisdiction, are within the jurisdiction of the social jurisdiction. So therefore, not basically on
Only on,
acquittal of
no,
a criminal proceeding.
no.
But how do you take care of paragraph number 28 of the judgment? The expression like benefit of doubt and honorably acquitted used in judgments are not to be understood as magic incantation. A court of law will not be carried away by a mere use of such terminology. In the present case, the appellate judge has recorded that Exhibit P3, the original mark sheet carries the date of birth of so-and-so and the same has been proved by the witnesses. The conclusion that the acquittal in the criminal was after full consideration of the prosecution evidence and that the prosecution miserably failed to prove the charge can only be termed as after a reading of the judgment in the entirety. The court in judicial review is obliged to examine the substance of the judgment and not go by the form of the expression used.
Well, this was, in my understanding, in a context that whether in the, my lord, subordinate court judgment, whether it is benefit of doubt, the word benefit of doubt was used, or acquittal, honorable acquittal was used, the court should not be influenced by those terms, and court should go in deep into the, my lord, judgment and see whether it was actually in benefit of doubt or in honorable acquittal, because this is a bit gray area. What is honorable acquittal? This is a bit, in some judgment.
No, or in
honorable ac-
other words, it would mean what it appears to be that don't go by the word, what is being used by the court,
Exactly.
but see the substance of the
Exactly.
judgment to
have
come
to
to
see
a
the
finding
court.
as to whether it is a case of honorable acquittal or is it on the basis of benefit of doubt.
Correct. There are another judgment, I think, some Singh, I just forgot the name, wherein also the Honorable Apex Court has said that mere using of the word acquittal or honorable acquittal or benefit of doubt, you should not go by that. You have to see whether it is actually honorable acquittal. And what is honorable acquittal? Suppose, or what is, sorry, what is benefit of doubt? Suppose some witness got hostile, or there are, you know, few examples were given, 2-3 examples. In that event, it can be derived conclusion. So that was, but still there are, but the main, you know, principle is that the core of the judgment has to be seen whether it was actually honorable acquittal or not, and it should hit the conscience of the court, my lord. That is the whole idea or principle.
So I have to say that my coordinate bench have held that wrongly.
No, your lordship has to, perhaps, subject to correction, we'll have to see the CBI court's judgment also.
No. The coordinate bench clearly holds that it is a case of
No,
benefit
in
of
this,
doubt.
in this case, my
In
lord,
this case,
no, I understand, in this case, perhaps
would it not be this court
charges,
overstepping?
in this case, charges are different. He was
No, I'm not saying.
Yes,
For the purpose of here, the coordinate bench in the criminal appeal held that the petitioner herein is being given the benefit, is being acquitted on the ground of benefit of doubt. Now, can I look into it and say that no, from the contents, it is actually an honorable acquittal, but not the question of benefit of doubt?
it will be a difficult task.
You will have a difficult, yes.
Because
the Supreme
if-
Court
if
could
the-
do for a High Court matter is okay. But if the matter has gone to the Supreme Court
Hmm.
and the Supreme Court mentions out there that it is on the basis of benefit of doubt, can a coordinate bench out there, while taking up the service matter, say that no, brother judges have made that mistake.
Milord-
I have a problem.
My lord, I would say, since the standard of proof is different in both the proceedings,
No, 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 no,
your
no.
lordship will not be
No, no. You
included.
see, no, no. If you go by Ramlal, the Ramlal says that look here, you don't go into the contents. You don't go just by the what is being written as honorably acquitted or benefit of doubt. You look into the contents and find out as to whether it is honorable acquittal or benefit of doubt. Meaning thereby, himsing is kept intact.
Yes.
Himsing is kept intact that in the case of a benefit of doubt, you are not entitled to. But if it is a case of honorable acquittal, you are. But the court says, the Supreme Court in Ramlal says that look here, you need to look into the contents of the judgment as to whether it is an honorable acquittal or it's on the basis of a benefit of doubt. Now my question out here,
Can
that
your
the
lordship,
ordinate bench holds it on the basis of a benefit of doubt. Can this court now say, no, look here, nothing, this is not the case out here. It should have been put as benefit of the honorable acquittal. Can this put?
purpose has to be seen, my lord, list before your lordships, what is challenged and for what purpose your lordships is taking that conclusion or making that assessment.
But can
That will
this court
be-
do it? Because that would be overstepping.
No, your lordship will be doing this for a totally different purpose.
Maybe, but that is the finding of, because here it says, kindly see.
If it benefit
kindly see,
of
here
doubt,
it say, a court of law will not be carried out by the mere use of such terminology. In the present case, the appellate judge had recorded that exhibit P3, the original and so have proved real. The conclusion that the acquittal in the criminal was after full consideration of evidence and the prosecution miserably failed to prove the charges can only be arrived at after reading of the judgment in the entirety. The court in judicial review is obliged to examine the substance of the judgment and not go by the form of the expression used. Meaning, what expression is being used? Now, this court, under 226, would then have to look into the judgment of a coordinate bench, wherein in the exercise of the criminal appellate jurisdiction, it has been held that it is on the basis of benefit of doubt. Could it be permissible?
my lord, such case has not, I haven't come across any case wherein this situation has emerged as of now.
This is the situation where I am faced.
Here,
Because here,
benefit
here
of
if you
doubt.
See the judgment,
It was, I think,
kindly page 117. 117 of the writ petition.
on benefit of doubt.
And hence the appellant is entitled to acquittal on the benefit of doubt.
Yes.
So now, in this court, sitting in exercise of judicial review, say that no, the word used out there as benefit of doubt was not the proper, it was a case of honorable acquittal.
But once it has been held to be on benefit of doubt, it's end of the matter. Only there is honorable acquittal as per Himsing, court come into play in departmental proceeding matters. Only there is honorable acquittal. Here benefit of doubts, my lord. Here that situation doesn't emerge.
No, in him saying, what does
Yes.
it say? Acquitted in a criminal case by itself cannot be a ground for interfering with an order of punishment imposed by the It is now settled the principle of law that the order of dismissal can be passed even if the delinquent official has been acquitted here, unless the accused has an honorable acquittal in
Yes.
the criminal trial, as opposed to an acquittal due to witnesses turning hostile or for technical reason. The acquittal shall not affect the decision in the disciplinary proceedings and lead to automatic reinstatement. But the penal statutes governing the substance, this is what is being said.
Yes, my lord.
So if that is so, and therefore
if
my
there is-
question is,
If there is honorable acquittal, then it's fine. And as per Ramlal, para 28, your lordships has to see whether it was an honorable acquittal or not.
So therefore, can I say sit over?
No, here it's a benefit of doubt.
Here it is.
Once it is benefit of doubt,
If it was
it's end of
given
the
by the
game.
criminal trial court, I can very well say, although the judge must have used the word benefit of doubt, it is actually a case of honorable acquittal in terms with himself. I can very well say. But can I say this? When a court will bench of that,
There will be
It may-
difficulty. There will be difficulty. There will be difficulty.
or for example, would the Supreme Court say, when a person have been acquitted beyond on reasonable doubt or on benefit of doubt by when held by one of the coordinate benches, and say that look at that is actually not content showed this. Wouldn't it be sitting over what the coordinate bench have? My question therefore is that,
Correct, correct. my lord.
wouldn't it be
Or
embarrassing?
if we
Wouldn't it
consider
be
vice
not-
versa, if
Huh?
we consider vice versa, suppose honorable court had held that, yes, it was a honorable acquittal, or from the contents, it can be deduced that, yes, honorable acquittal. Can the court, in a DP challenge, can say, no, there are enough material, it's a benefit of doubt.
over the same coordinate
There will be
bench?
difficult.
Or let us example, I was taking in the case on the criminal side then, and I hold it. Now, again, when I'm
On-
thinking of the writ proceeding, then I look into it, yes, actually this, can I do that?
Hmm.
That is the question.
I'll do some homework.
Huh?
I'll do some homework,
You don't do, we'll have with discussion some other day.
my lord.
You don't have a case.
But
My lord, I was just thinking over loud, thinking out loud, my lord. Your lordship would need not alter the aspect of a benefit of doubt or an honorable acquittal, because your lordship had said that your lordship is looking into the merit of a disciplinary proceeding. Now, your lordship will merely look into the judgment of the acquittal or the conviction and apply it in the disciplinary proceeding without altering the text or touching the aspect of whether the acquittal was honorable or
No, no, Mr. Sharma, those issues
yes.
do not arise here.
Yes, yes,
It's a
yes.
different
No,
that
understood,
way.
ma'am.
On a Thursday and a Tuesday, I go for a lot of academic discussions, the different aspect. But otherwise, the thing is like this. Your case,
Yes.
you first have to cross the bar.
Yes, 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 my lord. Because that inquiry report states,
And the
It's vague.
dismissal,
yes,
the moment there is a dismissal,
yes,
you have accepted it,
yes.
meaning
yes.
thereby it has to, and that dismissal was not based upon any conviction.
It was not, because it preceded that by a good 5 years. Now, my lord, the disciplinary proceeding, the wording of the disciplinary proceeding, the charges are the same as was given in the criminal proceeding. The terms which was said was that I was negligent and unbecoming of a public servant. But the entire crux of the charge at page 18, my lord, disciplinary show cause, it talked about forgery. But then the
Forgery was not the basis. If you see the inquiry report,
person which was
Yes.
cast as much as I
no,
understand,
see the inquiry report. It categorically says
Inquiry
nothing
report.
doing.
it was
That
my lord
was
at
not
page
the-
17, my lord. Just
No, no, I have seen
Yes.
it. Wait.
Yes.
Yeah.
Yes.
I read it, I remember.
The inquiry report, my page 46 to 47, man.
Wait,
46 to 47, the operative portion, my lord, that your lordship is referring to, 46 or 47.
but
Yes.
from the above, 47, it
Yes.
is well established that so-and-so acted negligently and committed serious lapse and thus failed to discharge his duty efficiently and diligently. The way the certified copy was prepared, signed and delivered amounted to failure to maintain devotion to duty and absolute integrity. The act done by the year was unbecoming of a government servant and it amounted to gross negligence to duty and misconduct.
Yes.
Then before that, of course, from the materials available before this inquiry, it is not possible to ascertain as to who has forged the original judgment.
Yes.
So therefore, the inquiry report did not go into that. Unbecoming of anything and all, these are issues which are there, whether they were the question, as regards a crime being committed is in respect to a forgery being committed of a court record. So that is absolutely on a different charge.
different charge, my lord, that,
Maybe on similar circumstances, there may be two different charges. One a charge for the disciplinary proceedings and one for the criminal proceedings.
Yes.
It may happen.
yes,
But merely because it is on the same cause of action,
Yes.
there are two different elements. Can you say that?
no, my lord, your lordship will kindly come to page 17 for just one moment, my lord, page 17. The inquiry report, it fortifies the allegation in the show cause, which is at page 70.
Hmm.
But the basis, my lord, is that the certified copies were issued after changing/forging the operative part. That part, which becomes the basis of me not following, not maintaining devotion to duty, and not me being not absolutely having integrity, that part has been set aside. Now, the root cause
Who
of
has
that,
set aside?
my lord, in the acquittal, my acquittal order, my lord, the
Of-
order of acquittal, the forgery, the aspect of forgery, the criminal
No,
aspect.
no,
of
forgery is different.
Yes.
Forgery of the document.
Yes.
See, it is the case of forgery of the document. What you have that was the allegation on which that happened. This is a case of forgery and taking money. But that is not the findings out here in the disciplinary proceedings, and which you have duly accepted.
Yes, yes, yes.
No, I think 2 o'clock I should dictate. Enough of academic discussion. So that has chapter has closed.
Normally in this type of matters, we go on proportionality.
Huh?
Yes.
Normally in this type of matters, we go on as a council, Miller, we project our case on basically on proportionality.
Was it-
Normally, keeping aside everything, Miller, we don't go in procedural aspect because there is nothing to be gone into. Everything has been accepted.
But therefore, one has to close it because
Correct.
otherwise this will be rising and giving. Yes, understood. If it was the basis of the conviction, this court would have a real.
Yes,
Yes.
But not this.
no, not this.
কি গগৈ সেইটো অৰ্ডাৰটো দি দিব দিম এটা যে মোচনৰ অৰ্ডাৰ দিলো দি দিম Mr. Patin, there is nobody out there from Arunachal?
Arunachal.
Mr. D. Pangin
Oh.
is the petitioner, no?
Ah,
For the petitioner.
Deepangi is the petitioner, advocate.
Mr. Gautam Vishnu, what has happened to that as regards my judgment in this slums matter?
My lord,
Will
another writ petition is pending before the.
No, that
division
is
bench.
different.
My
That
lord.
I'm not on that. But as regards the appeal, any appeal has been filed?
No, my lord. Till now, no appeal has been prepared.
So the same principle will apply in
My-
this
yes,
case. So therefore, the selection proceedings have to be interfered with here. Taking into account that there was a direction not to declare the results.
my lord.
And the petitioner has to be called
My lord.
for the selection as he holds the post out there to the post of, what do you call? Court
Assistant-
officer. He's a
He was a court officer, man.
court officer. So he is a court officer. So this document has to be interfered with.
Writ petition can be accessed.
In this case too, there is not even that rider also in the appointment order, page 32.
My lord.
There is some order by which his representation was rejected somewhere.
My lord.
Ah. Heard Mr. D. Panging, the learned counsel appearing on behalf of the petitioner. Mr. Mukpatin, the learned senior counsel, as well as the standing counsel of the Guwahati High Court. Itanagar Permanent Bench. I've also heard Mr. G. Busher, the learned counsel appearing on behalf of the Guwahati High Court, principal seat. First, the issue involved in the instant writ petition pertains to whether the petitioner herein has a right to be considered for promotion to the post of assistant register judicial in view of Rule 7, 4, capital A of the Guwahati High Court. Lamba hi naam to gute di but appointment something rules 1967. Full stop. The issue involved in the instant proceedings have been dealt with by this court in another writ petition. In the case of J. Islam versus the full naam to Diribo versus Iman, whereby this court, by the judgment and order dated so and so, date to Diriba, had categorically held that Zahirul Islam versus State of Assam and two others. WPC number 2755/2024. A judgment dated 31/7/2025, wherein this court had categorically held that the court officer who belongs, the post of court officer which belongs to class 2 Roman C of the Schedule 1 to the rules of 1967 have a limited right for being considered for promotion to the post of assistant register. Post. this court further held that the petitioner therein, who was the court officer, along with the AOJ, J to Brechter, and other officers who have been appointed to posts coming within the ambit of Class 2 Roman C, 2C of Schedule 1 of the Rules of 1967 have a right to be considered for promotion to the post of Assistant Register Ministerial Stream. The provisions of Section 7.4, Rule 7.4 of the Rules of 1967 are almost parametery to Rule 7.4a. Of the Rules of 1967. And as such, it is therefore the opinion of this court that the petitioner herein, who is a court officer, has a limited right to be considered for promotion to the post of Assistant Register Judicial. This court further finds it pertinent to take note of that the petitioner, on coming to learn that steps were being taken on the basis of a communication dated six communication dated steps were being taken on the basis of the communication dated 25/6/2024. For filling up the vacant post of Assistant Registrar Administration. Had submitted a representation for the purpose of consideration of the case of the petitioner. However, the said representation was rejected as informed to the petitioner by the communication dated 29/11/2024 by the Registrar, Guwahati High Court, Itanagar Permanent Bench. It is further seen that thereupon the interview process was initiated by the notice dated 16/12/2024, wherein the petitioner was not invited. Which resulted in filing of the present petition. This court further takes note of that on 20/12/2024, when the instant writ petition was moved, this court directed that the results of the interview conducted for the post of Assistant Registrar, Guwahati High Court, Guwahati Itanagar Bench shall not be declared. The resultant effect of the said interim order is that till date, the selection proceedings have not culminated. Next. This court, upon hearing the learned counsels appearing on behalf of the parties and taking into account that the similar issue have already been decided by this court, is of the opinion that the petitioner has been able to make out a case on merits for being considered to the post of the court officer, assistant registrar. Accordingly, the instant writ petition therefore stands disposed of with the following observations and directions. Number one, the petitioner herein has a limited right to be considered for the post of assistant registrar. The petitioner herein, who is presently discharging her functions as a court officer in the Itanagar bench, permanent bench of the Guwahati High Court, has a limited right to be considered for promotion to the post of assistant registrar. Number two, violation of the said right would amount to an infraction to Article 14 and Article 16 of the Constitution. Number three, the rejection of the petitioner's representation by the communication dated 29/11/2024 is on an erroneous reading of Rule 7(4)(a) of the rules of 1967, and accordingly interfered with. Number five, this court further, taking into account that the petitioner's right to be considered for promotion to the post of assistant registrar have been violated, interferes with the selection process so initiated on the basis of the notification dated 25/6/2024, which led to the notice dated 16/12/2024. Accordingly, the communication dated, notice dated 16/12/2024 and further proceedings and further decisions so taken, further steps so taken on the basis of the said notice, which is Annexure 15 to the writ petition, is interfered with. number 6. This court grants liberty to the respondents herein to initiate fresh steps for filling up of the post of assistant register judicial, na? Judicial or administration?
Judicial.
Administration. There's only one post or how many posts?
Judicial, my lord.
Assistant register judicial.
Judicial.
In the establishment of in the Guwahati High Court, Itanagar Permanent Bench, thereby inviting all eligible candidates coming within the ambit of section 7(3) of the rules of 1967, which would include court officers, which the post which falls within the ambit of category Roman 2C of Schedule 1 of the rules of 1967. No, next. This court further directs the respondent authorities to abide by the observations. Now, further observes that the decision, the decision in the case of Jairul Islam versus the state of Assam, dated 31/7/2025 in WPC number 2755/2024, shall be applicable. The decision as well as the parameters laid down in the said decision shall be applicable to the present case. While carrying out the selection to the post of Assistant Register Judicial in the Guwahati High Court, Itanagar Bench. With the above, the instant repetitions, that's the post, interim orders, if any, stands vacated.
My lord, in 16/12/2024, that notification, they have not mentioned, they have mentioned only post of assistant register. But the, when the representation was rejected by the authority, the post for assistant register judicial,
They say.
my lord. But in the notification, which is at page 38, annexure 15, only said the post of assistant register. One post of assistant register, annexure 15.
Assistant Register.
Yes.
Post of Assistant Register. How many posts of Assistant Register are there? You have not filed the application.
My lord.
Mr. Patin, do you have Assistant Register or Assistant Register Judicial? Mr. Busho, you just find it out.
My lord. I will
And let
find
me
it out.
know,
But-
when I
but-
sign the order, you just get me
My
that
My
information.
lord, in the notice also, it was mentioned as assistant register judicial. Copy were given, that notice dated 16/12/2024. They mentioned that copy was forwarded to assistant register judicial.
Just find out whether
Lord.
they have a post and just let me.
My lord, I'll inform you.
Release
Obliged.
item 4 will continue now.
Yes, heard Mr. M. Sharma, the learned counsel appearing on behalf of the petitioner. Mr. H. K. Das, the learned standing counsel
1 and 2.
appearing on behalf of the Guwahati High Court. The petitioner herein has approached this court by filing the present petition seeking a writ in the nature of certiorari for setting aside the dismissal order dated 13/3/2006 and to and for consequential benefits on the basis thereof. The case of the petitioner herein is that the petitioner, while working as a superintendent in the principal seat of the Guwahati High Court, was issued a show cause notice under Rule 323, Part Roman 4 of the Guwahati High Court Services bracket for appointment conditions of service and conduct rules 1967. As to why one of the penalties prescribed in Rule 22 of Part 4 of the said rules of 1967 should not be imposed upon the petitioner on the charge so levied. Petitioner submitted a reply to the said show cause notice denying the allegations on the basis thereof, and inquiry proceedings were initiated the inquiry officer submitted a report on, what is the date? 11/10/2004.
2004, my lord. Page 26.
Whereby the inquiry officer opined that from the materials available before the inquiry, it was not possible to ascertain as to who had forged the original judgment, more particularly page 9 of the original. And it was therefore opined that it cannot be held that the petitioner had forged the judgment. It was also opined in the said inquiry report that it was sufficiently proved that the certified copy of the judgment was prepared without following the due procedure, and that much irregularity and illegality was committed by the concerned officials, including the petitioner, who was the superintendent at that relevant time. Accordingly, the inquiry officer further opined that the petitioner had acted negligently and committed serious lapses and thus failed to discharge his duty efficiently and diligently. In the said report, inquiry report, it was mentioned that the manner in which the certified copy was prepared, signed and delivered amounted to failure to maintain devotion to duty and absolute integrity. The said act done by the petitioner, as per the opinion of the inquiry officer, was unbecoming of a government servant, and it amounted to gross negligence to duty and misconduct. On the basis of the charges, on the basis of the opinion so rendered by the inquiry officer in its report dated 11/10/2004, the petitioner was show cause as to why he should not be imposed with a penalty under Sub-Rule 8 of Rule 22 of the Rules of 1967. The petitioner thereupon submitted a representation on 15th of March 2005, so cause to dateful 8/12/2004. Petitioner submitted a representation on 15/3/2005 The representative submitted a reply on 15/3/2005. The reply so submitted, however, was not accepted, and by an order dated 13/3/2006, the petitioner was dismissed from the services of the Guwahati High Court with immediate effect. The petitioner thereupon preferred an appeal which was rejected by the and informed to the petitioner by the communication dated 9/6/2006. The petitioner thereupon challenged the termination of the petitioner, the dismissal of the penalty of dismissal of the petitioner, by filing a writ petition before this court, which was registered and numbered as CR or WPC?
WPC, my lord.
As WPC number
1982.
1982 of 2007. However, as would appear from the order dated, what is the date of the order?
10/12/2023.
10/12?
2023.
No, no, no.
No, no, my lord, it is,
This is a 2007.
yes, yes, yes.
The dismiss on.
155, my lord, this order.
Twenty-three. No, it can't be. It is wrongly mentioned.
2013, my lord.
It should be 13 million.
13,
I'll just
10,
cross
12,
check and
2013, my lord.
Because even 2020.
it can't be. My lord, it was a typographical error in
2013.
the index. It is 2013
13.
para 3.7, my lord. Of the pleading.
Where?
121.
121 page number.
121.
However, the said writ petition was withdrawn on 10/12/2023,
13, my
13.
13.
That too without any liberty. It was further mentioned, it is relevant to observe that in the order dated 10/12/2013 categorically mentions that the counsel appearing on behalf of the petitioner had submitted that the writ petition be dismissed as withdrawn, and the petition was accordingly dismissed. Full stop. The issue pertaining to the petitioner's dismissal for service pertaining to the legality of the petitioners, of the penalty imposed upon the petitioner of dismissal of service from service. Therefore, attained finality. In the meantime, on account of the allegation of forgery of the certified copy of the judgment, a CBI, it was a CBI, no?
CBA.
Yes,
A CBI investigation was initiated on the basis of an FIR. FIR?
Yes.
Huh? On the basis of an
The
The
Registrar
Registrar General-
General wrote a letter dated 4/3/1999 to
875.
SPCVI.
that's an FIR, no?
That's an FIR, my lord. Pursuant to that, case was registered.
A CBI investigation was carried out pursuant to an FIR being filed. which was registered as RC case number 5/99,
Five A, my lord.
/99.
Yes, 99. It's
Under sections 120B /420 /468 /471 capital A and 211 of the Indian Penal Code read with section 13(1)D and 13(2) of the Prevention of Corruption Act 1988. A charge sheet thereupon was filed against the petitioner and two others. Sometime in the year 2004.
before that, my lord. Before that, should be, yes, ma'am.
Which resulted in registration of a case being special case number 28/2004
Yes.
before the learned special judge CBI Assam. The learned special judge CBI Assam convicted the petitioner by the judgment and order dated 23/5/2012. Under section 120B/468 of the Indian Penal Code read with section 13(2) and section 13(1)D of the Prevention of Corruption Act 1988. An appeal thereagainst was filed. Which was registered and numbered as criminal appeal number
97.
97/2012. Which by the judgment and order dated 21/11/2023, a coordinate bench of this court set aside the judgment and order dated 23/5/2012 passed by the learned special judge CBI Assam in special case number 28/2004, primarily on the ground that prosecution could not establish the case against the petitioner under section 120B/468 of the Indian Penal Code read with section 13(2) and 13(1)D of the Prevention of Corruption Act beyond reasonable doubt. And hence it was held that the petitioner was entitled for acquittal on the benefit of doubt. Pursuant to the said judgment delivered on 21/11/2023 in criminal appeal number 97/2012, the petitioner straightaway approached this court by filing the present writ petition, even without approaching the Guwahati High Court on the administrative side. The record reveals that this court, by an order dated 5/4/2024, issued notice. The record further reveals that an affidavit in opposition has been filed by the respondent numbers 1 and 2. Wherein, amongst other aspects on merit, it was specifically contended that the issue pertaining to the dismissal of the petitioner, imposition of the penalty of dismissal of the petitioner, have attained finality. When the learned division bench of this court, by order dated 10/12/2013, had dismissed the writ petition as withdrawn. It was also mentioned that the petitioner was acquitted, that the acquittal of the petitioner was purely based on benefit of doubt. And such acquittal of the petitioner on benefit of doubt has got no bearing in the decision of the disciplinary authority. This court, the instant writ petition was listed before this court on 19/6/2025. Wherein this court put a pointed query upon the counsel appearing on behalf of the petitioner as to whether the instant writ petition challenging the order of dismissal can be maintained at this stage. The backdrop on the basis of which the said query was made can be seen from a perusal of the order dated 19/6/2025, and more particularly the contents of the said order mentioned at paragraph number 2 to 7, which, being relevant, is reproduced hereunder. Next. Upon such query being made, the learned senior counsel who represented the petitioner sought for time to address this court on the said issue. In the backdrop of the above, let this court now take note of the submissions so made by the learned counsels appearing on behalf of the parties. Mr. M. Sharma, the learned counsel appearing on behalf of the petitioner, submits that though the dismissal of the petitioner by the order of dismissal dated 13/3/2006 was prior to
The order of equity.
the conviction of the petitioner by the judgment and order dated 23/5/2012 by the learned special judge CBI Assam in special case number 28/2004. But do both the disciplinary proceedings as well as the criminal proceedings arises out of the same set of facts? He therefore submits that when the petitioner have been acquitted by this court by the judgment and order dated 21/11/2023 in criminal appeal number 97/2012, after looking into all the evidence, the respondent authorities have to therefore the order of dismissal dated 13/3/2006 is required to be interfered with, and thereby the petitioner should be granted all consequential benefits on the basis thereof. The learned counsel for the petitioner further submitted that the judgment passed by the judgment and order dated 21/11/2023 in criminal appeal number 97/2012 had given rise to a fresh cause of action to the petitioner, and the cause of action on the basis of which the earlier writ petition was withdrawn does not preclude the petitioner to file the instant writ petition, isn't it? Anything more?
No.
You want to submit about Ramlal?
Not really, my lord, because the facts is I've gone through the matter, and the case, the petitioner was acquitted only because the prosecution could not prove, and there's a difference between disproved and not proved. That's where the entire gamut lies. And whether the order of acquittal was based on reasonable doubt or a benefit of doubt, that is something which is up to your lordship's subjective determination. Reading the perusing order, I don't have any submission on that aspect. My submissions are limited to that.
These two.
Yes, madam.
Mr. Ichkedas, the learned counsel appearing on behalf of the respondents, submitted that the order of penalty dated 13/3/2006 is based upon the inquiry report wherein the inquiry officer did not go into the question of forgery, which was the subject matter of the criminal proceedings. On the ground of negligence and acting in a manner unbecoming of an employee, government servant, na?
Yes.
Government servant, or what do you use?
Unbecoming.
An officer of the Guwahati High Court.
Yes.
Officer, na? Of
Yes.
the officer of the Guwahati High Court. the penalty of dismissal of service of the petitioner was imposed. Petitioner, though challenged the said order of dismissal by filing the writ petition bearing registration number WPC number of 1982/2007. But the petitioner withdrew the same on 10/12/2013. That too without any liberty. He therefore submitted that the act of withdrawal of the writ petition without reserving liberty amounts to acceptance of the inquiry report, the punishment of dismissal. Dated 30/3/2006. And as such, the petitioner cannot be permitted to agitate the same issue after being acquitted, that too on the ground of benefit of doubt in a criminal appeal by the judgment and order dated 21/11/2023 in criminal appeal number 97/2012. The Learned Counsel further submitted, relying on the judgment of the Supreme Court in the case of State of Rajasthan and others versus Him Singh, reported in 2021 12 CC 569, that when the acquittal in a criminal case by itself, when an acquittal in a criminal case is not an honorable acquittal, but on the ground of benefit of doubt, it shall not affect the decision in the disciplinary proceedings and lead to automatic reinstatement. Anything more? No. I've heard the learned decision and analysis and determination. I got the contentions of the party, case of the petition, case of the respondents. This court have duly perused the materials on record, as well as taken into consideration the submissions so made by the learned counsels appearing on behalf of the parties as noted above. It is well settled that there is no bar on the part of there is no bar in proceedings with a disciplinary proceedings as well as a criminal proceeding. On the same set of facts. In the instant case, it would be seen From the inquiry report dated 10/11/2004, though charge of forgery was involved in the charges framed in the disciplinary proceedings. But the inquiry officer in its report categorically held that the charge of forgery could not be proved. However, on the basis of the evidence, the inquiry officer opined that the act on the part of the actions on the part of the act on the part the conduct of the petitioner suffered from negligence and was unbecoming of an officer of the Guwahati High Court. On the basis of those findings in the report, inquiry report dated 11/10/2004, the petitioner was issued a charge sheet, was issued a show cause, asking the petitioner to explain as to why penalty in terms with Rule 22(8) of the Rules of 1967 should not be imposed upon the petitioner. The petitioner, though, replied, but by the order dated 33/2006, the petitioner was dismissed from service with immediate effect. At this stage, it is very pertinent to observe that though criminal proceedings were parallelly proceeding, but there was no judgment delivered against the petitioner convicting, which was made the basis for the purpose of dismissal of the petitioner. Rather, the criminal proceedings being special case number 28/2004, to culminated only by judgment and order dated 23/5/2012, whereby the petitioner was convicted. That too, in respect to offenses which was not a part of the was convicted by the judgment order dated. The petitioner thereupon filed an appeal, and the said appeal did not yield any favorable result. The petitioner filed a writ petition, which was withdrawn, that too without any liberty. That too without reserving any right to approach in the circumstance, the criminal proceedings are decided in favor of the petitioner. The non under such circumstances, the order of dismissal dated 33/2006 had attained finality. And the same cannot be disturbed. Subsequent, and more so in a proceeding, and more so in the facts of the present nature, where the order of penalty was not based upon any criminal conviction. This court further finds it pertinent to observe that the setting aside of the conviction against the petitioner and that the judgment of the judgment and order dated 21/11/2023 in criminal appeal number 97/2012 may have acquitted the petitioner from the charges leveled against him in special case number 28/2004. But the said cannot reopen. But the said, in the opinion of this court, cannot reopen the concluded decision, the reopen the issue which stood concluded with the withdrawal of the writ petition, the issue of this of imposition of penalty of dismissal of the petitioner. Which stood concluded with the withdrawal of the petitioner of the writ petition on 10/12/2013. Accordingly, this court do not find any merit in the instant writ petition for which the writ petition stands dismissed.
Matter, madam.
Huh?
I may be allowed to ignore this matter, madam.
Why? What has happened?
But basically, he has no case, my lord. If you lordship will kindly see the advertisement, my lord, at page number 17, my lord.
You want to withdraw?
Yes.
Mr. S. Does the learned counsel appearing on behalf of the petitioner submits that he has instructions to withdraw the instant writ petition. Accordingly, the writ petition stands closed on withdrawal. Mr. H.K. Das appears on behalf of the Guwahati High Court. Mr. K. Gogoi, you are there? Appears for the government of Assam.
Highly obliged, madam.
Item 6,
Yes, this is the case of money not being given.
Yes. Lordship may kindly see the last order. Financial concurrence has been issued. Now judicial department has to do the need.
Done.
Not done.
Judicial Department. You are the AAG. You sometimes forget, appearing for finance, you sometimes forget that you also have an additional
But-
or the alter ego.
Yes, otherwise finance has given the sanction, my lord.
So what about the judicial?
That lordship will take up on Thursday, my lord. I will come up with the updated instruction.
Ah.
Or at least 2 weeks, my lord.
No, not 2 weeks. I'm not. This
Thursday.
file otherwise has to go there to, I'm not here in Kohima.
Lordship.
So then I can, this file has to be taken, okay, we can do so, imposing a cost upon you. Those person concerned will have to carry this file.
No,
Give a flight ticket,
on 28, my lord.
cost of flight ticket from here to the person to Dimapur, then the car on a, he'll take a good Innova car, come back, I think
28, my lord.
15,000?
28, my lord. I will have the
20.
latest instruction.
Mr. B. Gogoi, the learned additional Advocate General Assam,
Right.
who also appears on behalf of the Judicial Department, submits that he would obtain instructions as to whether the Judicial Department has placed the ex post facto approval so given by the Finance Department already
Right.
in respect to engagement of the petitioner as officer on special duty with effect from 21/6/2021 to 26/2022. This court further observes that the ex facto post facto approval having already been granted as observed in the order dated 26/6/2025 by the already granted by the Finance Department as observed in the order dated 26/6/2025. That this court directs the Judicial Department of the Government of Assam, if not yet sent to the Guwahati High Court, be sent on or before the next date.
Next date, my lord.
List the matter on 20/08/20.
Seven.
Please, Your Lordship. This matter refers to the registrar of the industrial tribunal, my lord, the fixation of salary, my lord.
Oh, yes, I asked you something, no, that
My lord. My lord, it is not covered under the National Judicial Pay, Second National Judicial Pay Commission.
why it is under the government of Assam.
It's under the government of Assam. My lord, the Second National Judicial Pay Commission is for the judicial officers, my lord.
Huh?
It's only for the judicial officers. I checked up, my lord. The other staff members are not covered.
No, you're wrong. It cannot be. You have not looked it properly. Look from all the judgment from 1991 onwards. You have to look into it, that these are there. Because I remember one matter I was dealing with a stenographer.
Well, the Shetty Commission is there.
Then
I'm relying on Shetty Commission.
SETI Commission, then comes the judicial, the
The order,
judicial
my lord.
commission comes on the basis thereof. It is only on the basis of the judicial officers, not the others.
No, my lord, Shetty Commission is for the staff, my lord.
Ah.
The present one, my lord, which was last year, my lord, 2024,
Mm.
my lord, that one is for the judicial officer.
Okay. That is the second one, na?
Second one.
And what
In-
about the first one?
First one was Shetty Commission, my.
No. After the SETI Commission report, there was a judicial commission.
My lord, that was the
first-
Padmanabhan, Justice Padmanabhan Commission.
That is the first judicial commission,
My,
pay commission. Then comes the second pay commission,
my,
which is now been going on, the
Right.
disputes, the state is not making payment.
Right.
Okay, now what do you have to say? This has a matter of importance.
my lord,
We have to look into it.
my lord.
Yes, finance, what do you have to say?
We have filed our affidavit. Here is a case, my lord, where they are seeking pay parity. Where the petitioner is seeking pay parity. Now,
Register,
register of industrial tribunal.
they come under you.
No, they come under the judicial department.
Judicial department is you.
Judicial department is us, my lord, but in our affidavit,
You
we
know
have,
only that the government should speak in one voice.
that is true.
That-
But we have filed,
Why this treatment, stepmotherly treatment be given?
apparently not entitled.
Why?
Because mode of recruitment is different, his service cadre is different, role and responsibilities are different, establishments are different.
He is asking parity with whom?
Parity with the Sirastadar of regular courts. District and Sesandar.
So you don't have a selection for this register post? No.
There is a process, there is a process. But we say, my lord, that they are not covered under the, my lord, pay structure of that of, my lord, chief administrative officers. Nowadays, we say this CAO, Chief Administrative Officer of, my lord, the district and session judge.
So who has the control over them? Who can terminate a register?
It is the judicial department.
You can terminate.
Yes, judicial
Does
department.
the High Court have any role over it?
High Court, perhaps, my lord,
Can the High Court have, because they come under the ambit of 235.
perhaps that is maybe a larger issue to be decided
So
here.
that is
My-
the issue. Because once the High Court comes in it, then the question will be, can the High Court deal with that? Because I'm taking up this bench,
No, absolutely.
taking into account that it comes under the these departments. Now, whether a register of an industrial tribunal, the judge of an industrial tribunal is being spared from the judicial service.
Judicial service.
He's spared from there. Means he's brought from there. Because there, I think you need an appointment for him to be a district judge.
Yes,
Being posted out there in the industrial tribunal.
yes,
The release order, everything has to be given by the state.
yes. State.
Now, the question is, can this court exercise, the Guwahati High Court on the administrative side exercise jurisdiction?
My lord, it comes under the ambit of the trial courts, my lord, of the subordinate judiciary, which the government itself says.
That is it.
It says, my lord, the government I have annexed the documents, my lord, where they say it comes under the ambit of subordinate judiciary, as it was known then.
They
My-
mention in the,
My lord, it is mentioned here,
where is it?
my lord. My lord, page 79,
Wait,
page 79, my,
of your petition.
of my petition, my lord. This is the order implementing the Shetty Commission's recommendations pursuant to the Supreme Court's order.
What does it say?
Lordship may come to serial number 11, LTC, HTC benefits. Just below that, staff's employees, the paragraph thereafter, my lord. The aforesaid benefits shall equally be applicable to staff of corresponding grade and status working in various courts like MACT, Family Court, Industrial Tribunals, Labor Courts, Court of Special Judge CBI, Special Judge Assam, Judge Designated Court, etc. in Assam, which fall within the sweep of the term subordinate judiciary. This is the government's letter, government's order, my lord. In fact, my lord, the other tribunals like MACT, my lord, Family Court, the Seristadars there, as well as they enjoy the same scale as per the Shetty Commission, as is given to the district and session judges.
So you're equating with them?
My lord. My lord. All of them get it, including, my lord, the industrial tribunal staff. The stenographer gets it, but I do not. The reason which they say is the term registrar of the industrial tribunal or labor court is not mentioned in the Shetty Commission. Now, we have a situation here, my lord, when the stenographer, though I am the chief administrative officer of the highest in the ministerial staff there, my lord, I am getting a salary lower than that of the stenographer, which was not looked, which the Shetty Commission said that is not permissible. This particular notification,
But
said
as per them, what is the post of a register?
they do not say anything.
Huh?
They do not say anything.
Means
They-
they don't come anything.
They do not say anything, but my lord, the
Did they create the post?
yes, my lord, it is created by the government, my lord,
So at the time of creation of that post,
my lord.
it was equated with what? The
Uh,
pay scale.
pay scale, my lord. At that time, my lord, My lord, I have given a table at page 20.
Page 20.
Page 20, my lord. In 1996, my lord, the registrar scale was same as that of the district and session judges registered. My lord, 1998 also it's the same. 2003, 1st of April, from which date, my lord, the Shetty Commission's recommendations were implemented, my lord, the Serisadar scale went higher. And Lordship will see the second column, the third column, sorry, my lord, is of the stenographer. At the moment, my lord, the stenographer is earning more. The grade pay of the stenographer is higher in the tribunal.
But that was, the stenographer was more in 1998 also.
Yes, my lord, it was more then. But the Shetty Commission said, my lord, that the chief administrative officer of a court has to have the highest pay. Pursuant to that, my lord, the Seristadars in the district courts, their pay scales were increased.
Now in 2012,
My lord,
you are put at the same pay scale,
but grade pay,
but the grade pay is different.
my lord, grade pay, my grade pay is lower.
Two 2016 also, the grade
My-
pay.
My lord. The
So now
scales-
you want your grade pay with that of the Seristadar.
Seristadar. And this is the grade pay which is given to the MACT, family court, all other tribes.
They are having what?
My lord, the same pay scale and the grade pay as the
What does the family court and all have? Registrar?
Seristadar. Seristadar.
So what this court now has to do is put this GP 12,700 to 14,500.
My lord.
That's your prayer.
My lord. My lord, which was the recommendation? My lord, it's an administrative recommendation of the judges committee, my lord. The judges committee had looked into it, my lord.
They have
But
also given that.
Yes, my lord. I have annexed that, my lord, at page 84. This is, my lord, a resolution of the Honorable Committee on 5th of October 2012, starts at 82, the operative portion at page 84. Resolution number 5, my lord. That is, it appears that the government of Assam, in the notification dated 30th July 2012, which Lordship has just read, has mentioned that the benefits given by the said notification pursuant to the directions
The Seristadar of MST courts appointed.
by the Transport Department, if I'm not mistaken. By the Transport Department.
Here in our affidavit, we have categorically stated that the Register of Industrial Tribunals and Labor Court falls under the administrative control of the Labor Department. Whereas the Seristadars are within the domain of the Judicial Department. Their mode of recruitment are entirely different. Now, this
What is the difference?
fundamental difference is being, my lord, this is a direct recruit post. The post which the petitioner is occupying, my lord, that the Register of Industrial Tribunal, that is a direct recruit post. And these are promotional posts.
How? Promotional under what provision?
Promotional, my lord, under the rules, my lord, they say.
Under which rules? Because your rules of 1987 is not there.
Not
Do
there,
not
but
apply.
it is being done in that manner, my lord.
No, that manner means that you have done it good. But the thing is, which rules? Rules of 87 would not apply for MSK. Because that is not a cadre post.
My lord?
87 rules are on the basis of the posts which are there in the cadre.
Yes. that Existing.
MSCT is not there
MSCT
because
is not there.
MSCT was not born then,
Absolutely.
and neither it has been born till date. Here in the 87 rule, we
So there-
don't have the final rules.
Yes, so therefore, my lord, my affidavit also speaks about, my lord, the proposed draft rules, which
Your
are.
proposed draft rules, your
Contemplation.
legislative department, although finance has okayed it, your legislative department comes up with the saying that this finance department and the high court, they don't know how to draft. So this is how we have it as of now.
Proposes, my lord, Assam service rules for the registrar appointed to labor courts and industrial tribunals under the Labor Welfare Department, Government of Assam, 2024. This is also, my lord, in contemplation. Has furnished the draft rules. That lordship
So you
will,
are making for labor courts another one.
yes, my lord.
So that means you are thinking of segregating from the district judiciary. Are you having for the MSC?
That, I cannot spell it right now, my lord, I don't
Because
have the
he is equating
instructions.
with the MSC. na?
My lord.
The moment you are having somebody for the labor court, some establishment, you are having something different.
Yeah.
Meaning thereby you are segregating the labor court from the subordinate judiciary.
Judiciary. Tires are different.
So you are segregating. But as of now, the opinion of the LR, which is given there, still remains. Whereby you bring labor court within the subordinate judiciary of the labor court, the labor court within the ambit of the subordinate judiciary.
That is in contemplation. That is in contemplation.
No, that's the opinion of the LR which has been given. That is what he was showing it.
Therefore, it has not attained finality.
Why not? That has attained finality long time back.
2012.
Huh? So the High Court, as they construe the labor court and its stuff, come within the ambit of the subordinate judiciary. So therefore, it will come under the ambit of 235 and 236.
Yes. Right.
And if it is comes under the ambit of 235 and 36, can they say that this post is this or that post how? Who is going to make the equation? Equation has to be made by the controlling authority.
Yes, fine.
The controlling authority will be the High Court.
It will be the high.
So the question arises out here is that the directions which have been passed on the service conditions as regards the equation, because the High Court equates the district court as well as them together. The finance cannot have a say on that.
Finance cannot happen. Not only the
Because the moment finance has its say,
there would be
the finance may say, don't create a post.
yes,
We don't have the money.
yes. Mine.
But the equation
Right.
which is being made has to be done by the High Court. Otherwise, it touches on the independence of the judiciary.
Yes, Lordship is absolute. Whatever has fallen from Lordship's mouth, it's absolutely right, my lord. Otherwise, but it is akin to usurping the jurisdiction.
Good. I
In
think
fact-
you're right.
In fact, the pay commission recommendations are also to the effect, my lord, that the services of the registrars has to be brought under the Assam Labor Service Rules 1970. This is the, my lord, recommendation of the pay commission. recommendation, the commission recommend that the post of registrar, that is my lord, page 136 of my affidavit, my lord. The commission recommends that the post of registrar from industrial tribunal, labor tribunals be placed in pay band 4 with grade pay of rupees 5,900. The commission further recommends bringing the services of the registrars under the Assam Labor Service Rules 1970.
Where?
My lord, page number 136.
Which part?
My lord, issues, lordship will find it at
Post
my,
of register industrial and labor to be placed in PB4 with grade pay of 5,900. The commission further recommends bringing the services of the event. Now, this is what he's asking. He's also asking that.
then my lord,
No, if you are relying on that, kindly look here. He's asking for this only. Yeah, this is this one. Kindly see page 20.
page 20 of the writ
His
petition, my lord.
petition. 12,000 to 40,000. The GP 5,400 is being given to him. The commission recommends to make it 12,000 to 4,000, 40,000 plus GP 5,900. Your commission also recommends that.
We shouldn't recommend it, but my lord,
So you are relying on something.
no, my lord,
No, your commission has
no, no, commission,
recommended that.
yes, commission recommended, but again,
Says that it should be with
no, my lord,
stenographer
again, it
basis.
was, again, it was put to test, my lord. My lordship will kindly
As per
say,
your commission, it should be with stenographer grade work.
no, that is the recommendation of the commission initially. Now what, it was put to test before the anomaly committee. Now what the anomaly committee prescribes, that lordship will find at 137, page 137, annexure C,
137,
my
yes.
lord.
Where?
My lord, down below. Labor Department, 1.88. Enough justification is not found in the report regarding enhancement of grade pay of various posts like junior instructors of vocational traders, registrars, industrial tribunal, labor tribunals, etc. Hence, the committee is of the view that these posts may be given grade pay corresponding to their existing pay scales. The department may examine feasibility of the recommendations regarding individual cases and submit a proposal to the finance department with detailed justification in the light of para 1.59 of the committee's report.
Where is 1.59?
1.59 is not here, my lord. Yes, 1.59, my lord, I have spelled it out in my affidavit itself, my lord, I have quoted it. Lordship may kindly come to page 119. Is the part of, my lord, paragraph 6 of my affidavit.
Yeah.
In
With regard
italics,
to
my lord.
many
The committee observes that with respect to
Recommendation was not found in view of the possible ramifications, the recommendation in man department of the guide. Here, the judicial officers' pay is outside. Let us see the ROP. Move the table of the ROP. Table of ROP gone.
the latest recommendation in the ROP lordship will find at page 133, my lord, of that affidavit.
What is it?
My lord, the pay structure of different posts have been, my lord, incorporated therein, my lord, with regard to, my lord, district establishment under the judicial department.
I to copy the DI. 130.
133, my lord, 133.
First, let us look into these roots. So as regards the ministerial staff of the subordinate judiciary, the rules of 2017 shall apply.
Yes, this is what my lord tell out,
Isn't it?
my lord.
My lord. Subordinate judiciary case.
Huh?
Of the subordinate judiciary,
Only the ministerial staff,
only ministerials.
because they only don't apply to the members of the Assam Judicial Service,
Right.
officers and staff of the Guwahati High Court.
Right.
So officers and staff is out because of 229.
Right.
Judicial officers are out in view of the independence of the judiciary.
Right.
For that, it is out. So therefore, as regards the ministerial staff, the ROP duly takes care of.
Right.
Now, if the ROP takes care of it, does the ROP has for the post of register?
No, ROP do not have it.
Does the ROP has anything as regards the solicitor of the court? Then
Yes,
how are you
Saristara,
doing?
it is there.
Where?
Not.
No, Lordship will kindly see, my lord. Lordship will kindly take up page 133.
No. Go for me and from the ROP.
No, this has been amended, my lord, in terms of,
This is the ROP, Mr. ROP. You go by the ROP, not by your one.
it's a part of the ROP, my lord.
Where?
Well, page 133, kindly see, my lord, page 133 for a moment.
130?
133 of my affidavit, my lord, Annexure A. In exercise of the powers conferred to Provision 309 of the Constitution, Governor of Assam is pleased to order that the following amendments shall be made in the schedule to the Assam Revision ROP 2017, published in so and so. In the pay schedule under the head Judicial Department, below the subhead District Establishment Non-Judicial Staff, the following new entries in column so and so shall be inserted. Name of the post, number 1, Lordship will see Seristadar, Additional District Judge, Head Assistant, Seristadar Civil, Seristadar Munship, Stenographer grade 1, 2, 3, Bench Clerk grade 1,
Yeah. Civil judge
and my lord, that's
in the post existing, so this
Yes,
is blank.
and
Assam Legal
now-
Service, Legal Remembrance Secretary,
Hmm.
Joint Demand.
Then serial number 34, Lordship will kindly see page 130, 134, my lord. Serial number 34 down below.
So
The
they are
CEO,
after 550. Why we don't have pages thereafter? People have 550, 551. Legal remembrance, variance superintendent, upper division assistant. Lower division assistant, stenographer, grade 2, and so record player, supervisory assistant. Labor commissioner, then. Labor officer. Employment. Under what head you are putting these people? The register? Yeah. Got it. Labor code. You see, therefore, you are paying it in under you. This is being done by you. Therefore, I was asking you.
Yes.
555. Presiding officer, register, record keeper of the labor code are here. So you are putting them outside the Assam Judicial Service, even the presiding officer.
that is altogether
So
different.
this goes against what the LR's opinion is.
Fine.
It is. That is why.
No, in fact, it is also incorporated in paragraph 6 also of my affidavit.
What does it say?
Paragraph 6, page 118, my lord. So it might
Assam
say,
Public Service Commission, whereas the post of chief engineer in the district is the promotional. And how are you paying the MSCT?
MSCT that lordship will find, my lord, at page 134. Is a part of that notification whereby, my lord,
This is under which department? Transport.
no, MSCT will come under, my lord, the judicial department perhaps, my lord, because in the
No,
ROP,
no, Judicial Department it won't come.
no, but this, my lord, notification of 30th of May 2024. Whereby,
Who are establishment of senior government advocate, superintendent, upper division assistant, lower division assistant, so and so, record ranger, labor department, labor commissioner, ESI scheme, panchayat, labor department, industrial training center, labor court. Legal services, joint legal services. MSCT will be under what?
well, at page 134, in the notification, what I find, my lord, at serial number 34, for a moment, if lordship see it, my lord.
Chief Executive
Chief-
of District Court.
No, district just oblique, lord, oblique MSCT, oblique special judge, CBI, NI, NDPS, judge designated court. And this carries, my lord, the highest, my lord, grade pay, 14,500. And 14,500 is being carried by 3 other posts, that serial number 35, lordship. at-
So therefore you have added them
Yes,
in
For-
the judicial department.
yes. We say, my lord, that,
But you are putting them in the head of labor department.
yes, because,
As per 555,
because it is ultimately, my lord, at the end of the day, who is the controlling authority?
labor court is under which division? Department 555. Industrial tribunal. It is brought under the Labor and Employment Department. This Labor Court and Industrial Tribunal is brought under the Labor Department. And whereas those are under Judicial
So
Department.
this is what we have also spelled out in our affidavit, my lord.
But how do you recruit MSCT?
We say, my lord, that that is a direct recruit post.
MSCT register?
MSCT, my lord, we have not spelled it out here. So far as
Yes,
the petitioner
Mr.
is
Das.
concerned.
The member, who is the concerned member, he will not, it does the recruitment by issuing an advertisement. So far as I know,
Directly.
yes,
So it is same.
because he is the appointing authority, I think, in any case. The member concerned of the tribunal. Because one or two cases which came up before the court, that the advertisement was issued by the member MSCT.
Lordship will find the answer, my lord, at page 120 of my affidavit. Kindly, I am troubling my lord with, because
Yes.
I'll have to spell it out, my lord. Page 120, my lord, the last paragraph. It may be mentioned that the nature and mode of recruitment of the two posts are fundamentally different. The post of Registered Industrial Tribunal or Labor Court is a direct recruitment post filled through the Assam Public Service Commission. Whereas the post of Chief Administrative Officer in the District Judiciary is a promotional post. Eligibility for promotion to the latter requires a minimum of 3 years of continuous service in the cadre of Senior Administrative Officer or Head Assistant under the District Judge or the Chief Judicial Magistrate. This distinction in appointment qualification.
No, I understand that. Yeah, because the rules of 87 come into play. But MSCT doesn't come. How are you equating at serial number 34? The same chief executive officer of MACT with the district judiciary, if they are also a direct recruitment, is it because there the member does it and here the APSC does?
Yeah, now that answer is also here, my lord, paragraph 7, my lord, page 121.
Yeah.
With regard to the so it is a fact that judicial.
Applicable only to non-judicial staff of the subordinate or further, it has been stated in the resolution that the benefit to extend to working staff in judicial court pursuant to
Next.
not establish fact that the post of register of demand is equivalent to chief executive of the district of and no, this is okay. This is again equivalence you are trying to make with the CEO
Yes, CEO.
of the district judiciary. I'm not on that.
Yeah,
I'm
because
saying about the MSC.
MSCT, yes,
Because
we have not spelled it out, yes.
Or
But-
you have brought in, equated them,
Yes,
and if the MSCT person is to be appointed by direct recruitment,
yes,
then
yes.
My lord, there is another aspect, if I may be permitted.
please.
My lord, if my lord comes to my reply, my lord, my reply affidavit, my lord, page 149 and 150. My lord, that the judicial department does not exercise any control over the industrial tribunal, that may not be correct, my lord. As page 149, it is, my lord, about the allotment of budget for industrial tribunals, labor courts, as well as MSCT. This is issued by the judicial department. This letter is issued by the judicial department. And
Yes, but I am directed to inform you that the services of judges and establishment of Iman and its establishment has been brought under grant fee along with the relevant head of accounts of labor and Iman and taxes and so and so.
MSCT is taxes on vehicles. And
Because you see, the correspondences which are being made has to be made by the judicial
Judicial.
department.
Right.
No, that is okay, but
Right.
therefore the question here to be put to the finance department are twofold. First, if the High Court exercises the power under 235 and 236, the High Court is the person who can equate, not the finance department.
not the finance.
Number two, if they have equated the CEO of the of the district judiciary with the register of the MSCT, what stops them? Because MSCT register is also a direct
Direct.
recruit.
Right.
And then what stops them from doing for the register?
Exactly. Mine.
Is it because they are put in a different head? Or is it because these people appointed?
Mine.
I think this is the
Yes,
instruction we require,
mine.
which is not clear from the
Mine.
finance.
Apart from that, two other posts are there, three other posts, Lordship will kindly see page 135. Because Lordship is taking a cue, my lord, at serial number 34 of that notification. Then serial number 35, 36, 37, court manager. He is also carrying the same grade pay, highest grade pay, 14,500. Then superintendent, family court, 14,500. Head assistant, my lord, district judge court. Yes, of course, it is, that is lower. So therefore, we find three posts, my lord. CAO of the judiciary, special judge, CBI, designated court, MSCT. And my lord, this one, court manager, then superintendent family court. Precisely what I find from the affidavit, my lord, perhaps because of the administrative control, the difference have cropped up, because they have treated this under the my lord, judicial department, all these
No,
posts.
therefore, these rules are very relevant in the sense. What the government has been doing is, as for judicial officers or people coming under the AGS, they are outside the 2017 rules.
Yes.
However, a judicial officer who has been put to the labor court,
Yes. Yes.
he's otherwise a judicial
Yes,
officer,
yes.
but he's put to the labor court. the payment is being made from the labor department.
Yes.
Meaning thereby the government has treated him to be within the service of the government, maybe on deputation or something to the,
Maybe, yes.
it seems something like
Yes,
that.
yes, yes.
So therefore you have put these people on that side. Now, the appointment to the post of the sub registrar, the registrar is being made by the APSC, as you say. Whereas, as regards the MACT, these are done pursuant to certain judicial orders passed by the Supreme Court for having tribunals. So although they don't form within the cadre of the district establishments,
Yes, yes.
but on account of those judicial orders, these forums are being made.
Absolutely. Yes, yes.
And by executive instructions, they are being regulated and given the power to the High Court to do it.
Yes,
It seems something like that.
yes, yes.
So, but the labor court, would it come within the ambit of it?
Yes.
This is a the important issue.
No,
Now, if it doesn't, so you cannot be, because here what you have done, you have brought the presiding officer within the scope of the ROP.
Yes,
This is a very important aspect.
yes,
Meaning thereby you are taking him
yes,
outside the Assam Judicial Service
yes,
or even taking him outside the scope of 235 and 36.
yes.
Isn't it? It's a very important aspect. Whether your High Court realizes this, asking you.
Just trying to understand your lordship's query, my lord, in question.
No, what has happened is this. ROP rules categorically say that it shall not apply to Assam Judicial Service. It does not apply to the staff of the Guwahati High Court or the officers of the High Court. That is under 229. The other is also on the aspect of 235 being given and all these things. So they are not being brought in. I think most probably the salary and all, although the government fixes it, but actually, if ROP does not say so, that it is being done on the basis of those SETI Commission's recommendation as well as the judicial commissions. These are evolved on the basis of judicial pronouncements and regularly the All India judges cases being taken up. So they have not brought them in. However, a person who can be a presiding officer of the labor courts, it is being given out there in the Industrial Tribunal Act and the Industrial Disputes Act.
Yes.
They are treating the officer who is an industry, who is being the presiding officer within the ambit of the state government employment. Meaning thereby, if they come under the state government employment, would they not be out? Or wouldn't their appointment out here be something like a deputation?
Yes. Or
Because otherwise they are Assam Judicial Service.
yes.
So when an Assam Judicial Service comes out here, he's outside. Thereby, the power under 235 and 235 is taken out. Because it is being brought within the ambit of. As regards the ministerial staff, they have put it in the ROP because that is not excluded in the ROP.
Yes.
They have put the ROP. And they have put them within the ambit of the judicial department. But what they have not done, as regards the register or industrial tribunals register or the presiding officer, they are being put under the labor head. The appointment of these people, the register and all, is done by the APSC. Meaning thereby it is a completely different outside. Meaning thereby the High Court has no jurisdiction.
He is as good as general government employee.
General government. So he's outside. So what has happened is they are putting the labor court and industrial tribunal outside. But whereas MACT, which is also an evolvement, because labor court is on the basis of Industrial Disputes Act, Whereas MACT is an evolvement of judicial judgments.
Right.
And therefore they are fixing it, all Althea and appointment, all these things are being done. And they have said that, okay, as these are judicial judgments on which it is happening, the staff, everything will come under the High Court. And this is how it is being practiced.
One thing, my lord, in this,
Mm.
if I have understood my lord, correctly, SETI Commission recommendation, this all, everything originated from the SETI Commission recommendation. Then SETI.
No, you see how the SETI Commission's recommendation come in. The person concerned who was having this All India Judges case, the association, they filed a writ petition initially.
Yes.
And initially when the writ petition filed, the court passed certain orders. A review was filed by some of the states as well as the union, which resulted in reviewing the earlier order passed in 1991 by an order in 1993. This resulted in an appointment of the SETI Commission by the government, and thereby the SETI Commission's recommendation came in, which have been accepted in many parts. Some have been not done, some have been accepted. This has been done, going on, which is being done. Now, the SETI Commission's recommendation also mentions about the industrial tribunals.
Yes, Industrial Tribunal and Labor Code.
Now, if the SETI Commission does it, recommendation is there for them, then wouldn't they come within the umbrella of the High Court?
Yes, that has to be explored. Yes, it's.
Because this will need a lot of deliberation in this aspect. You have to look into this aspect. Because this will be taking out from the ROP and fixing it another head of the judicial department deeds.
I'll do one thing, my lord. I'll have a talk with the
Industrial
regis-
Disputes Act also. Because I remember earlier, MACT also had that problem. But nowadays, I think the government must have given up the control. We don't want to fight with the High Court. So they must have given up the control. Earlier, if I remember a long time back, if a person has to go from MACT out there, they have to take a release from the government. One point of time. Why was it necessary? An MACT judge being appointed to the district judiciary, he had to take a release order from the government.
Yes.
He cannot be directly put there. Labor court, yes. Tribunal. The appropriate government may, by notification in the official gazette, constitute one or more labor courts for the adjudication of industrial disputes relating to any matter specified in the second schedule, and for performing such other functions as may be assigned to them under this code. A labor court shall consist of one person only, to be appointed by the appropriate government. You see this? His appointment is by the appropriate government. This is 7(2). So therefore he is outside. It is more like a deputation, a person of a judicial service, Assam Judicial Service is being sent. It is more like a deputation he said. A person shall not be qualified for appointment as a presiding officer unless he is or has been a judge of a high court, or he has for a period of not less than 3 years been a district judge or an additional district judge. So this, he has been a judicial officer in India for more than a year, has been a presiding officer of labor court constituted under the provision. He has been he is or has been a deputy chief labor commissioner. See? And he is an officer here. So the labor court is completely outside the purview of the Assam.
It doesn't, the presiding officer,
Ah.
after being appointed as presiding officer of the labor court, he doesn't remain a part of the judicial service.
He does not.
Exactly.
That is what it is.
Exactly.
So then, can this court, in exercise of its administrative power, the 235 equate the service and give recommendation. Think, ponder.
Yes.
Yes. Evidently, my lord, statutory requirement under the statute.
So therefore,
Recruitment under-
it is as if the High Court is sparing the services of these and sending him there. Tomorrow, if it is just, for example, it is sent to the DRT. Same provision
The
applies.
question will be whether if we not understand or appreciate these facts with the para 23 of RENU, whether this labor code and, you know,
Industrial
MSCT
tribunal.
or
No,
industrial.
MSCT is outside. Let us
Labor
not
code
bring
and
MSCT.
Yes, labor code or industrial tribunal will fall into the category of subordinate code.
It won't.
It won't. That
It
is
won't in view of this.
It has
And
been
therefore,
completely
they have
separated.
put them under the ROP.
Exactly.
And
Because
if
this
they
is
are not, then 235 does not come into the play.
exactly. That is also prima facie, Milord, without going into the details. I also feel like that.
So then, once the High Court doesn't have the jurisdiction, I have the jurisdiction to take up this matter on this bench.
Yes.
No, my jurisdiction out here to take up this bench is as regards the ministerial staff of the sub-district judiciary, as well as the High Court, the staff, officers and staff of the Guwahati High Court. That's my notification.
Correct.
Now, can this matter be placed before me or should it be placed before the bench three?
That is also a question.
Yes.
That is also a.
Huh?
Because, yes, since long, Milord, this matters concerning labor code and all, those are coming to your lordships and this bench only.
The labor code don't come. Labor code comes in, bench 4 I can take it up as bench 4.
No, labor code, Milord, employee matter also.
But this is service, na?
Yes,
I am outside service.
yes,
My bench roster does not.
yes.
How can I take up this? Think and ponder.
Yes.
No, no, we will.
I'll ask the Chief Justice to give me that additional roster.
No, we are grateful, my lord. That these issues have sprang up, my lord, during deliberation. We are so grateful.
In fact, not in this, this ROP, in the previous ROP also, 2010 also, Milord, this labor code and Milord, industrial tribunal was incorporated. Since long. it is there,
Therefore it has to.
Yes.
You see, it is an establishment of the government.
Yes.
Yes.
The High Court has no power under 235. So the recommendation so made by the High Court is wrong.
Yes. In a way.
The High Court may exercise 227. The power of superintendence. But the High Court cannot exercise the power of administration.
True.
That seems to be my prima facie opinion.
Yes. I'll just.
Therefore, perhaps, my lord, because of that aspect, my lord, perhaps, my lord, the finance department has structured this affidavit basically on functional test. My affidavit is basically premised on functional test.
Therefore, no, what they have done is they have brought in the judgment of 2018-19 SCC and more particularly the conquering opinion of Justice Sapre and say that these recruitments are different and therefore this has happened.
That's a classic decision. We always rely on paper 92.2.
So that is what he's doing. That I get but this is what.
Lordship is correct, my lord. Lordship, keep it, my lord. Let us ponder it on this aspect.
One aspect of the matter, lordship was one document, that is the post-creation document. Post-creation, not like a post-creation document is there in the petition itself.
Page 30 onwards.
There, your lordship,
Yes, what is it?
page 32,
From 30.
page 32.
Yes.
This was the post creation letter.
Hmm.
Labor code. The register pay scale at that point of time, 375. Perhaps it will be third CPC, I think, Lord. 375 675. Down below,
Where?
page 32 for labor code.
Ah. Presiding officer one,
Yes, 1000.
register one,
Yes, and register one in the scale of pay 375 to 675.
Ah.
Stenographer one, then 140 to 300.
So these are the pay.
And industrial tribunal.
The report.
Yes. Industrial tribunal register.
Now,
is
does the
equivalent.
people from the secretariat get the SETI Commission's recommendation insofar as the stenographer?
Stenographer,
No.
that instructions I will have to take.
No, they don't.
They will not. my lord.
SETI commission is perhaps, my lord, it is premised on the judicial staffs in the judiciary, my lord, to put it in that way. SETI commission springs up, my lord, with different parameters, my lord, arising out of, my lord.
But SETI Commission says that labor court registers shall be equated with them
No, man. City Commission doesn't say so.
as because in the labor court,
No.
no. Therefore, that is the problem.
Now, one aspect of the matter, I am thankful to him, page 32, which Lordship is just now seeing. Kindly see the opening paragraph, my lord. I am directed to convey the sanction of the governor of Assam, from the state, to the creation of industrial tribunal and labor code at Dibrugarh in addition to so and so, so and so, so and so, to the following creation. So the creation is by the government under the statute.
No, here also the creation of posts for the ministerial staff of the district judiciary is also by the government.
No,
The governor has to do it.
No,
There's no
government-
quarrel with that.
No, why am I making that submission? Whether the establishment itself is created under the statute by the department, by the government.
No, no, it is the establishment is under the government. Because the government does,
Yes,
as per the industrial disputes.
yes.
Because it is a, by virtue of the statute, it has to
Statute,
be
yes. It's a
by
mandate.
the government.
Yes, by the government.
And it is therefore, the appointee is of the government. And it may not include judicial officers also, it may include anybody else. Even a labor officer will
Labor.
be.
No, my purport was, my lord, with whether Article 230 administrative control of this honorable court is attractive.
Very
Because judicial establishments, my lord, with all respect, are not created by the government. My lord. It is created by the High Court.
Huh?
My lord, the judicial establishments,
The posts are not created by the High Court. The posts are created by the governor.
posts are created, but the establishment itself. Whether there will be a district court, my lord, here or
No,
support.
this is by this Bengal Civil Codes Act, no?
Yes.
The establishment is on the basis of that act.
that-
So here the establishment is on behalf of the Industrial Disputes Act.
Yes,
So therefore, by virtue of that, the High Court gets the jurisdiction.
yes,
But here, with the High Court gets the jurisdiction.
yes. Now, whether we can stress it.
If you want, we'll.
No, my lord, we are pondering on
That,
it.
I think, my prima facie opinion, that would be, you see, tomorrow if we hold here, what stops us from holding that the DRT would also come within the High
Yes,
Court,
Yes,
235?
yes.
Why the 235 exercise is not done in respect to DRT by the High Court? Tell me. It's also a tribunal.
Tribunal.
Is it because of the central government there and the state government here?
Yes,
Or is it that you can
yes.
you can take action against the state government more and less against the central government? Is it something like that? Because otherwise, what stops the High Court exercising 235 in terms with the DRT? Same.
Yes.
It cannot be.
So same principle will apply here.
Because
High Court has no jurisdiction. It is a different thing. The High Court passes orders allowing deputation in view of 235
Yes.
of officers in the district judiciary to go on deputation there. It's a different thing. That in the act, the power exercised by the High Court is only sending him to deputation.
That also I'll clarify whether our officers go on deputation or what.
Has to be. Because of the fact that this is a different department you are sending.
No, if we read the appointment procedure, it appears that a person who demits office from the judicial service, he joins that post.
No.
No, serving.
No.
Serving.
Serving is.
Anybody who has 3 years. See,
No,
he
is it-
has
As on today, there are
for a
instances, my lord.
period of not less than 3 years been a district judge or an additional district judge.
Okay.
So therefore it is being sent on deputation.
Yes.
I remember there are many
yes.
officers I've met.
Yes.
I've argued many matters in the labor court. I found many officers out there who later on became district judges also.
Yes, yes.
This is how it is being done. So it is a case of a deputation.
Yes.
Question now is, do I lose my light?
মানে
But what I find, my lord,
Managing the
broad issue will be, my lord, to put it more
non-functional basis
simply,
of-
my lord. But it will be a purely judicial authority and a quasi judicial authority. That will be the, my lord, determining factor. Because under the High Court administrative control, it is purely and purely nothing but judicial authority. No, my lord, quasi judicial authority creeps in. What I find, subject to lordship correction.
Now tell me, if I hold in any manner that the SETI Commission's recommendation would not be applicable,
Yes.
because he's saying,
Yeah.
he's asking for SETI Commission.
Yes, yes.
In view of the reason that this is a separate establishment,
Yeah.
what will happen to the stenographers who are getting the benefit?
And the other staff,
Huh?
Yes.
including
And
the
the
other
other
staff.
stuff,
Other
because
stuff.
what has happened is you are giving the benefit to others.
Yes.
They may have an impact.
Yes.
Yes, yes, absolutely.
And the finance is very quick in making recovery. Huh? You ever look? This is a very important issue.
No.
No, my lord, we are extremely grateful, my lord, because I didn't even perceive, my lord, that this questions will come up from the court.
So therefore you look into this.
Yes,
Because
my
it
lord,
will
absolutely.
have a lot of ramifications. The moment I say that it is outside,
Right.
because his submission is, I should be given the set as per the SETI Commission.
My lord.
And if I reject it, it will, the reason I have to reject it is outside the purview. And if it is outside the purview, because then, therefore I asked him whether the SETI Commission's recommendation would be applicable to stenographer grade 1 in the secretariat. No. So then their pay will be less. If I'm not wrong. That we'll look into. So it will have an impact. So the instant petition having been heard at length and taking into account the interplay with the Industrial Disputes Act 1947, which confers authority upon the appropriate government to establish labor courts as well as industrial tribunals and appoint officers and staff. And further taking into account Article 235 and 236 of the Constitution. This court is of the opinion that a further deliberation would be required in the instant proceedings. Considering the above, list this matter on 18th of September 2025 for further. You look into this, huh?
Yes, yes, absolutely, my lord.
Matter be shown as parted.
Deeply obliged.
Parted, it's not required. Parted, then I retain the jurisdiction. Huh?
Yes, absolutely.
As of now, but the opinion which we are forming is that it goes outside my jurisdiction.
No, no, my lord, we are always grateful. It's a learning process, my lord, every day.
Item 8.
And so,
Deeply
obliged, my lord.
My lord, in this case, my lord, item number 8, my lord, we have received the instruction, my lord, I will be preparing the affidavit.
It's the Vijay Mohanto, the learned senior counsel, appearing on behalf as well as the standing counsel of the government of the Guwahati High Court.
3 and 4,
submits
my lord.
that he would be filing his affidavit within 3 weeks. List this matter on 18th of September
My lord.
2025. In the meantime, the affidavit be filed
Yes.
by 11th of September. 3 weeks. I'm giving you 1
My lord.
week, 2 week, 3 week. September, it's a liberty given to the petitioner to file reply, if any. We fixed on 25th of September. Liberty, the affidavit be filed by 15th of September. Liberty given to the petitioner to file the reply. if
My
he
lord,
wishes.
deeply obliged.
For orders, item 9.
The lordship,
Oh, yes.
On behalf of the.
What happened?
On behalf of restaurant number 2, the affidavit we have filed. And my lord, from the deputy commissioner, I
Have
have.
you paid the 10,78,000?
10 lakh
no, your
78
lordship, they haven't paid it.
10 lakh 78,000. 10 lakh 78,000 of financial sanction has been given on 21/7. It is already, it is with the finance department, my lord, the FOC has to be issued by them. They have, my lord, from our side, my lord, they have contacted. The finance has to release the amount, my lord. Immediately the FOC is given, they will disburse they will get the amount, my lord. They have already taken up the matter with the finance, my lord. Some time is required for that, and for the rest of the amount, my lord, the order was for 15 lakhs. The deputy commissioner has given us a letter, my lord, that ultimately they could only verify this amount, and they have requested for filing a review petition in the judgment, my lord. That will do, that is different, my lord.
No, the first and foremost, when you have filed an affidavit by the
What?
deputy commissioner.
No, for the response number 2, my lord, we have filed.
No,
2 is the additional secretary, my lord.
I'm not concerned. When the deputy commissioner has filed an affidavit
My lord,
stating categorically, look here, he is entitled, not entitled to 28 lakhs and odd, but he's entitled to only 15 lakhs.
my lord.
On the basis of that, this court passes an order. Now you say that, look here, what we said in the affidavit is wrong. Now, who is the person here record to announce? We draw contempt against him for filing false affidavit before this court.
My lord, the subsequent developments, they have,
We'll
they have
do
given-
one thing. We get the writ petition listed. And it has been mentioned by the district commissioner on affidavit, so we make him
my lord,
draw contempt against him.
my lord, Annexure 1 to that affidavit I have seen, my lord, that has been given to me also, my lord. Give us some time, my lord, because subsequently they said that bills could not be verified and that it was a letter sent by them under some circumstances, my lord. That will bring, my lord, on.
No, Mr. Nath, you have to understand. You cannot file false affidavit before the court, because if we don't take this seriously, the impact will be more felt by you. Any person, any officer by closing their eyes may file any affidavit. On the basis of that, the court will pass orders. After passing of the order, then the next officer who comes, he will say that, look here, he had filed the affidavit, which is the case here.
My lord, as it seems today, my lord, that's true.
This not seems to be, this is what you are submitting.
True, my lord.
So if that be so, isn't it necessary as a deterrent to put that particular officer behind the bars, at least for falsification of affidavit before this court? At least he will be learning a lesson and asking the state to also take disciplinary action against that officer. I think this is the better course of action.
my lord,
Okay. List this matter. Mr. D. Nath, appearing on behalf of the respondent number 2, submits 2, na?
now I am appearing for 1, 3 and 4,
Ah.
1, 2, 3, 4, but
Respondents
Wait, I have
1, 2, 3, and 4 submits that on account of the release by FOC being not granted by the finance department, the respondents are not in a position to release the said amount of rupees 10 lakhs 78,220. Full stop. He submits that immediately upon granting of the FOC, comma, by the finance department, comma, the said amount would be disbursed to the petitioner. Full stop. List this matter again on 22nd of September 2025. Full stop. A further opportunity is granted to the respondents to take effective steps for the purpose of release of the amount of rupees 10,78,220 on or before on or before 19th of September 2025. Full stop. This court further takes note of that the order which have been violated dated 16/9/2024 in WPC number 8105/2019 was passed on the basis of an affidavit filed by the District Commissioner Dhemaji, stating inter alia that the petitioner was entitled to an amount of rupees 15 lakhs. The said aspect is now sought to be contradicted, stating that as upon verification, the petitioner is only entitled to rupees 10,78,220. Full stop. The above aspect therefore means that a false affidavit have been filed by the then district commissioner, which was the reason for which the false affidavit have been filed before this court by the then deputy commissioner, Dhemaji in WPC number 8105/2019. The registry is directed to bring on record the writ proceedings, bring the records of tag the records of WPC number 8105/2019 so that appropriate orders can be passed for filing false affidavit before this court.
Lordship may also give an opportunity to them, my lord.
Huh?
Lordship may also give an opportunity to them, my lord. They let them reconcile it in the meantime.
No, that person has to be sent to jail
My
for
lord, they-
filing false. I'll be asking them. They are to take initiate proceedings under the new BNS. What will be earlier? We knew 340. Now whatever may be, some action has to be taken for filing false affidavit. That person, and I'll say that action should because once that comes in, I will issue the notice to him, and then I'll proceed sumoto. Don't worry. Your government will be satisfied then that something has been done.
Deeply
Else
obliged.
pay the
Your Lordship.
15 lakhs in the meantime.
Deeply obliged.
They're very serious of a thing.
As per office note dated 2/8/2025, Lordship. Yes.
Huh?
As per office note dated 2/8/20.
Contempt, another contempt.
Lordship, in this case, Lordship.
What has not happened? Payment,
Payment of the order is at page 10, Lordship.
service complete.
Not a complete, Lordship. As per-
Okay, the
as per
service
office note
being
dated-
not complete, the list the matter after. After,
Respondent number 4, Lordship, respondent one refused to receive the Lordship, and R3 is incomplete, and 2 is not yet returned back. And R4
service
send a
being
letter.
not complete, petitioner is given liberty to take fresh steps.
Also, R4 send a letter to the registry. R4 send a letter to the registry.
regarding,
R4.
otherwise not complete, no?
Others are one to three does.
You want to take steps by Dusty?
That's, if lordship allowed,
I am not. If you ask, I can. I have no business on. That is your thing. Otherwise, the matter
that's
will
it,
come.
may be allowed.
The council, appearing on behalf of the petitioner, submits that taking into account that the service upon the respond numbers 1, 2, and 3 is not complete, he may be given the liberty to take steps upon the said respondents by way of Dusty. Pustak. Taking into account the said submission, liberty is given to the petitioner to take steps by way of Dusty upon the respondent numbers 1, 2, and 3, routed through the registry of this court and file an affidavit of service on or before the next date. List this matter again on 15th of October 2025.
Obliges.
Yes, what is this? Mr. P.P. Bora, what have you done?
Lordship is there. Yes.
And there is a to place before this court the record of the selection, if any, on the basis of which the respondent has been promoted to the post of remand on the next day. Oh, yes. What is this? You have, without selection process, you have.
No, there is selection process, madam.
Genuine.
Yes, madam.
Then records I have asked you to.
Yes, sir, records are there. Received the records. And the private respondent is there, madam. We have served him copy.
Private respondent, Mr. Esdas will appear. We know the lawyers who appears for the High Court. E. Chakraborty, District Parawise, the resolution of the.
Madam, the record is after the para is comment.
Content of para, the petitioner, the date of birth, and the matter. That's well. We are concerned with senior administrative officer, na?
Madam.
What is the name of the petitioner? Abhijit Paul.
Abhijit Paul, madam.
Abhijit Paul. And man, here, for the phone number of vacant post of plan. Interaction. Years of.
Let me come to page 15. Towards left hand corner. My notes dated. My note 24/6/2025. Which starts from.
Mr. Council, wait. For eligible to the area, you have put your signature?
Yes, sir.
For eligible candidates for promotion to the post of senior administrator held on 28/3, full signature of the candidate.
No, that is 28/3 minutes, Lordship. That minutes, it is minutes of 24/6.
The board after due they have resolved to call the eligible members of Himalayan. Or junior administrator for the solution of. Criteria of the senior. They resolved that after picking up of the. 16/5. And after due. Ah. Mr. Bushra, this is not proper.
My lord.
Lahok. You stay. Stay the appointment. You file your affidavit.
My lord.
You see, isn't the promotion by seniority come merit?
My lord.
You have not called anybody. You have looked into the ACR, and on the basis that he has got 2 and 3, 2 very goods and 3, and this person has
3
got
goods.
so and so, he has got something. Are you not looking into the basis of seniority?
My lord.
I mean, merit.
My lord.
Done. You cannot. Okay. Heard Mr. B.P. Bora, the learned counsel, appearing on behalf of the petitioner, and Mr. G. Busher, the learned standing counsel of the Guwahati High Court, who appears for the respondent number 225. Mr. M. Setia appears for the respondent number 1.
1.
And none appears on behalf of the respondent number 6, though the respondent number 6 have been served through the standing counsel of the Guwahati High Court. The petitioner herein, that pursuant this court, the petitioner herein is aggrieved by the selection of the respondent number 6 to the post of the senior administrative assistant. Though the petitioner was senior to the respondent number 6. This court, pursuant to the order passed by this court on 1/8/2025, had directed the production of the records before this court, on the basis of which the respondent number 6 was promoted to the post of the senior administrative assistant. So Mr. G. Butcher have produced the parawise comments as well as the records, and more particularly the minutes of the resolution
24/6, my lord.
dated 24/6/2025, on the basis of which a decision was taken to promote the respondent number 6 to the post of
Senior administrative
officer.
assistant, my lord.
Huh?
Senior administrative assistant, my lord.
Agoto assistant. This court have duly taken note of the resolution number, which is at item number 2, and more particularly item number 2. And from a perusal thereof, it reveals that the decision which have been taken is on the basis of merit, come seniority, on the basis of merit, and not on the basis of seniority come merit, which is the criteria, the later of which is the criteria for promotion from the post of junior administrative assistant to the post of senior administrative assistant. Accordingly, this court directs the respondents to bring on record their stand by filing the affidavits on or before 19th of September 2025. List the matter on 25th of September 2025. This court, having perused the materials and record, is of the opinion that the appointment is prima facie of the opinion that the appointment made in favor of the respondent number 6 to the post of, the promotion made of the respondent number 6 to the post of senior administrative assistant by the order dated 2/7/2025 is not in consonance with the applicable rules as well as the settled principles as to how the merit cum seniority is to be evaluated. Considering the above, the order dated 2/7/2025 by which the respondent number 6 have been promoted to the post of senior administrative assistant is stayed till the next date. An attempt shall be made to dispose of the petition on the next date. Next date, I'm going to finish it off. Take the records, file an affidavit or not. Today I don't have the time, otherwise I'll have finished. But without the respondent number 6.
My lord, in the other matter, Arunachal matter, I had a discussion with the registrar, assistant registrar, judicial matter.
No hearing. Hearing any?
Deeply.
Yes, anybody has anything? Anybody wants to do any matter now?
Why not 3 days holiday? Everybody has got holiday good. I think you lordship.
Huh?
Tomorrow, not tomorrow, this Sunday, 3 days holiday. So everybody has got a holiday mood right now, I think.
Oh, yes. Yes.
my lord.
You are too busy. You don't appear when the matters are called. So you were appointed as an amicus.
My lord,
And you don't give any importance when the court
My lord,
appoints you, and this court had to act as an amicus there.
my lord, on that day I was,
State of affairs.
it was not a fixed matter. I was not there. I had to be there for my mother's problem.
Oh.
My lord, in any case, there was a written argument filed by me earlier.
I
It
did
is,
look into it, but anyway,
this item number 17,
yes.
can it be on 21st?
No.
Is a
There's
labor
too
code?
many matters. 21st, how many matters are? 22 matters are there. All are hearings. No. I can fix on one good date. Wait. 27th of August.
No, my lord.
27th of August.
No, my lord, not on 27th. My lord.
29th of August.
Or in the month of
26th or
September, my lord, in the month of September after,
26 or 28 August,
my lord, September, my lord.
or 2nd or 4th.
Well, I'd like to do the matter before lordship.
No. Okay, list on 2nd of September.